Good afternoon, everyone. Welcome to the Appellate Division, First Department. We have more than 6 hours of argument time requested for this afternoon, so please bear that in mind when I call your case. Remember that we have the briefs, we have the record, we're familiar with the facts of the cases, and so please ask only for the time that you will need in order to make your most important points. People versus Justin Lopez. Submitted. Bass versus LT. Okay, I'll leave it at that. 5-2, 5-2, 2 and 2. Royale C is submitted. Peña versus Kokata. 6, 2, and 6. Kaplan versus WebMD.
Your Honor, 7 and 2, please.
6 and 2 and 6. People versus Bryant Bigot. Biget. 5 and 1 and 5. Black versus Geneva. Forgive me if I'm mispronouncing any of these names.
Defendant Appellant Endure LLP, 6 and 2, please.
6, 2, and 6. Thank you. Uni-Rty Corp versus NY Guangdong Finance.
Your Honor, 8 and 2.
Going to do 6 and 2, 6 and 6. Real World versus 393 West Broadway.
Plaintiff Appellant, 6 and 2, please.
5 and 2 and 5. Gopi versus CVS Albany.
Gopi, Your Honor.
Gopi.
5 and 2. Respondent CVS, 5 minutes. Respondent 1688 rollout, 3 minutes.
That was 5 and 2.
3 for rollout, Your Honor, and 5 for CVS.
5 and 2, 3 and 3. First Specialty versus JRK Property Holdings. Submitted. Aponte versus Town of Islip.
Defendant respondent Town of Islip, 5 minutes, please.
4 and 2, 4, 4 and 4. People versus Paul Dilla. 7, 1 and 6. Phipps versus Cavallal, that's submitted. Sire Spirits versus Beam Centauri.
Paul Fishman for the appellant, Your Honor, 7 and 2, please.
For the respondent plaintiff, 7 minutes, please.
7, 2, and 7. First case for argument is Bass versus LT.
Good afternoon. May it please the court. My name is Lindsay Caldwell. I'm from Litchfield Cabo, and we represent the Appellate Grenadier Corporation. On October 30th, 2015, a piece of limestone facade on Lord & Taylor's flagship store on 424 Fifth Avenue dislodged and struck the pedestrian plaintiff, causing personal injuries. Lord & Taylor owned the building. WJE was the engineer of record, and Grenadier was one of several facade contractors that worked on the building on a case-by-case basis.
Grenadier worked on that building between 2006 and 2007. Isn't that right? That's when they performed
Yes,
work on the facade.
Grenadier,
Yeah, and there's evidence that there was product used, that the piece of the building fell off. That was the time that the building there was work done on it. And there was evidence that a piece of the building fell off in the location where Grenadier was working. And it had a material in it that could have caused this expansion and led to the spalling of the cement. Aren't there questions of fact here in this case that present, because they worked on it during that period, that prevent summary judgment to Grenadier?
Grenadier was tasked to work on the horizontal portion of the third floor water table. It's limestone, it erodes with rainwater, so WJE, when they were doing their local law 11 inspection, tasked Grenadier with repairing the horizontal portion of the water table only with a waterproofing membrane. WJE never told Grenadier to go along the vertical edge of the water table. When WJE was doing its inspection for the local law 11 work, it found spalling along the vertical edge, some holes and blemishes, but it determined that these were not unsafe conditions, so they didn't require any work to be done on that vertical edge, only the top. So we were on the top in late 2006, and we were performing work with the waterproofing membrane and a material called rapid mortar by Thorock. The product sheet is in the record at
So
it's 1912.
you didn't use the product, the Zamac Nilian.
No, we were never provided with any Zamac nail-ins for the job. We didn't have any Zamac we only use the tools and materials for each job. Grenadier doesn't do a single bit of work without having the tools for it, the instructions for it, getting paid for it, and then having emails and pictures showing the work that it did. There's no evidence of any of that. There's simply evidence that it was on the horizontal portion doing the work that it was prescribed to do, and it wouldn't have any Zamac nail-ins on it to do that work. And that's why the appeal record is so big, because we provided all of our records of work on the site over a 10-year period, I believe. And it shows that we were never on the vertical portion where the spalling was located. So just because we're up nearby.
So you're on the horizontal portion that sits right on top of the vertical portion that fell.
Yes.
And your position is there's no way working on the top would have in any way affected the vertical portion right below it?
Yes, because the reason the piece dislodged was that there was a Zamac nail-in that was used to fill that spall at some time. The building is 100+ years old. There were so many contractors that were there over a 100-year period. We don't know.
We're not talking about a 100-year period. We're talking about the period between 2006 and 2007, which is a period during which you worked on that very area, the horizontal area.
Yes, and I was illustrating that Grenadier is the easy contractor to go after because we did all of the local 11 periodic work. But in between the local law 11 work, there could have been other contractors at the site. Local law 11 is only to fix the unsafe parts of the building. But in between those cycles, There can be other contractors on the facade. When Lord and Taylor was getting proposals for work in 2015, right before the accident happened, it solicited bids, and it got bids from 3 contractors showing that, yes, there are multiple contractors on the working at the premises.
Isn't there information, may I?
Go ahead.
May I ask the question? Isn't there information from a Jim Triano in the record where Mr. Triano actually said something to the effect of, or he said he was looking at Exhibit B6, which must have been the photograph showing the anchor in the water table portion, and he said something along the lines, embedded steel mesh that Grenadier would have installed as part of the repair. So he sort of put you there. I think it's record 1606, 1607. So this could have led, notwithstanding your argument here that you had nothing to do with that, that created an issue of fact that sort of keeps you in the case.
Mr. Triano's theory is speculative. He looks at historic landmark designation photos and that he pulled from online to show that there used to be a spall in '06, and by the time the building was designated as a historic landmark, that spall was repaired. But he's using these photos that could have been airbrushed to make the building look good. I assume they're from a PR, a press release. So perhaps the picture that he's using is doctored to make the building look better for the press release purpose. Or there was another contractor at the site between '06 and '07, and Lord and Taylor, because it went out of business and ultimately bankrupt and could barely produce a witness and could barely provide us any records, they could have had another contractor up at the facade.
Wasn't there ample
filling-
time to have done discovery about whether there was any alteration of the photographs?
No, Your Honor. It was late in the process, and we've looked, and I've looked with my IT department and my law firm to see if there was any evidence of it being doctored, and, you know.
Thank you.
Okay.
Hey, good afternoon, Your Honors. May it please the Court. My name is Guy DeRosier, representing the respondent appellant Lord and Taylor. If I may, I'd like to use my time by first addressing and responding to Grenadier's appeal, and if there's a little bit of time left, I can then proceed to my appeal. Let me start maybe with the
Actually,
one.
I have a, before you do that, I have a question. It seems to me that what the record indicates is that Lord and Taylor circulated a request for proposals around 2015 for facade work, got a bunch of proposals, decided not to go with any of those proposals, said that they were going to start over, and then never did start over. So doesn't that create a question of fact as to whether some issue existed that caused them to ask for proposals and they then never took any steps to address it?
Well, if I may, Your Honor, the record is quite clear as to what the genesis for those proposals was, and it was specifically for an aesthetic project. They were looking at redoing the paint on the building. It was not
Wasn't
prompted.
it in a portion of the facade that was close to the area where the stone fell from?
It probably would have covered the entire facade, but there was no, the argument that we make is that there was no safety reason why that work was bid out. It was purely aesthetic. It was really to redo the paint. And I know one of their...
It went out with regard to restoration of the facade, but the restoration was only paint?
Well, they were supposed to strip the paint and also to do some incidental pointing and whatever other work that would normally go with that kind of work, but it was not something that was prompted by any kind of safety issue. I think
That facade is stone, isn't it?
it's limestone, yes.
You're going to paint the limestone?
That was my understanding, that this was essentially a paint project. And there's evidence in the record that, I mean, one of the witnesses for, I believe it was for Grenadier,
Which witness?
Mr. Todt, I think, had done the photographs as part of a walkthrough in order to submit their proposal for this paint project. And when he was asked, there's this photo in the record with the two circles in it. First of all, I draw your attention to the fact that the circles were drawn by the president of Grenadier after this litigation was commenced. But the person who actually took the photograph was Mr. Todt. And when, at his deposition, he was asked what he saw in those circles, he said, "I just see peeling paint." And so, the whole idea that the project was for anything other than a purely aesthetic issue is just not supported by the record.
Also, didn't Toth make it known to Ramirez of LT that he expected stone patching work to be performed as part of that work? Didn't he testify to that?
It would be normal to, as part of the painting project, if there was any small work that needed to be done, that would be part of the overall project. And obviously, they would have set up a sidewalk bridge as part of that. But again, the question is whether this was prompted at all by a safety concern, and it was not. There was never any issue with respect to safety in any of the local Law 11 cycle reports prior to that. So the project was purely for aesthetic purposes. It was not meant to address a safety concern at the time. So the fact that the sidewalk bridge was not erected, maybe it's a but-for cause. I mean, I'm not saying that if there had been a sidewalk bridge there, the plaintiff would not have been injured, but it was not a proximate cause because there was no duty owed to the plaintiff to erect a sidewalk bridge because the project was purely for aesthetic reasons. There's nothing in the record to suggest otherwise. If I may very briefly address the Grenadier's appeal, I do want to make clear that we have a very strong circumstantial evidence case against Grenadier. There's no dispute, first of all, as to what this piece of material was. And the clearest photograph you can see of that is on page 2447 of the record, which clearly shows the patch with the nail drive anchor, the Zamek nail-in within it. We also know exactly where this patch is located. Again, there's photographic evidence from a photo authenticated by the plaintiff at page 4832 of the record. And if you compare that to a photo that was authenticated by Mr. Triano at page 2454 of the record, you'll see that the condition is exactly the same. I see that my time is up. If I may just have 30 more seconds to conclude.
Okay.
Sure. There's no dispute also as to when the patch was made, and this is a very important point. If you compare the photo on page 2328 of the record, that's a spall that was there in 2006. It's the aesthetic spall. The photograph is from the Cycle 6 report that was prepared by Wisjani. And if you compare that with the photo on page 2456, 2457 of the record, which is the landmarks photograph. And again, there's no evidence that this was doctored at all. And I certainly don't want to go outside the record, but we did obtain these photographs through a FOIL request, and we have the metadata for the photographs. So there's no suggestion in the record that this has been doctored.
May it please the court, Nick Bagley for plaintiff respondent. If I could just address the Lord and Taylor aspects of it. The Supreme Court did not err in denying their summary judgment motion as they found that they had constructive notice of the hazardous condition. In July of 2015, there was a walkthrough performed by Lord and Taylor, Mr. Ramirez, and Dieter Toth from Grenadier, and photographs were taken. And during those photographs, there's one that's in the record, 1324, which shows the exact spot where the piece fell and hit my client in the head. That was circled, and Mr. Delmonico, the owner of Grenadier, testified that this was a hazardous condition, and they needed a lot more work than just paint.
They needed patchwork, too.
Patchwork. And if you look at 1325, which is the proposal, it discusses stone patching beyond 1 inch deep, stone repair with Dutchman, which is a more extensive patch. So they were on notice at least 3 months prior to the accident. Mr. Delmonico even testified that it was a hazardous area and that he believes Dieter Toth told Ramirez they should put up a sidewalk shed immediately. That's Mr. Delmonico's testimony, 1123. And Mr. Ramirez from Lord and Taylor testified that it did not surprise him that a piece of the building had fallen off since it was going to happen sooner or later. And addressing Grenadier's
That
point.
wasn't an expert opinion, was it?
Well, as the facilities manager for Lord and Taylor, in charge of 40 employees, it could be considered that. In terms of Grenadier's,
Hardly specific,
very specific, and he quit.
hardly,
Oh, hardly.
hardly.
And he quit the day after the accident.
It was the day off.
And in terms of Grenadier, the Supreme Court properly found that questions of fact existed as to whether Grenadier launched the force of instrument of harm under Espinal. The nearly 5,500-page record is filled with evidence that Grenadier negligently created the repair. The photograph from 2007, which was discussed from the Landmarks Preservation Committee, showed that that area was, in fact, cleaned up.
Thank you.
May it please the court. Joseph McNulty from the firm of Blick Law on behalf of respondent WJE, Wish-Janie Elsner. I don't have much to add, just a few points with regard to Lord and Taylor's appeal and the argument that there are no questions of fact as to whether Lord and Taylor exercised reasonable care in maintaining its building facade. As set forth in the record, it's clear that Lord and Taylor chose not to hire my client, Wish-Janie, to perform construction and observation services during the course of the work performed by Grenadier in 2006. Instead, Lord and Taylor made the decision to allow Grenadier to effectively self-police its own work crew. And that's, in fact, what happened when they certainly could have, but chose for financial...
That's an unusual decision in this industry, correct? Isn't it the common practice to have
Yes,
an engineering company supervise the company doing the actual facade work?
Your Honor, I'm not going to say that I can speak to whether it's common practice, but I do know that there were other projects performed for Lord and Taylor in which my client was retained or hired to provide construction observation. I would submit that it was an economic decision made at the time, and the history speaks for itself as to what happened as a result of it. Also, I would just underscore the decision made by Lord and Taylor not to proceed with the work in 2015, in which they went out and received 3 bids. They received the scope of work, which was more than just painting. It was stonework. It was a number of different things. They were also informed by Grenadier, as indicated by counsel, that there should be a sidewalk shed put up. And instead of proceeding with this work, which according to Mr. Ramirez would have been performed in September of 2015, and quite possibly could have extended through October and been in place, the sidewalk shed that is, at the time this accident happened, they decided to forego that, to kick it out to Cleveland and their construction department out in Cleveland, where it got lost in the administrative bureaucracy of Lord and Taylor, and it was never followed through on. So
Thank you.
thank you very much.
If I may, I'd just like to conclude with 2 points. Mr. Ramirez, Lord and Taylor's former facilities manager, testified that he was not surprised to learn that the building's facade was falling off and that, quote, it was going to happen sooner or later. It's an old building. After the walk around, Grenadier's witness testified, we advised Mr. Ramirez he should have put up a sidewalk shed immediately because you have hazardous conditions. You're not going to just paint your building. You've got a lot more stuff going on there. You should put up a bridge right now. Here's the quotation we think it takes to repair your building, and here's a separate quotation from Atlantic Scaffold to protect your sidewalks. And the historic preservation, the landmark photos, they show at the corner of the building, there's 2 painted areas right on the corner that Grenadier didn't do. So that shows some other contractor was up there painting these 2 corners on the edge of the building. There's no evidence in the record we did it. There's no evidence in the record that we were ever given.
Counsel, didn't Mr. Toth state that Grenadier usually used Zamac nailins?
We use
And
them.
wasn't that found in the piece that fell on the plaintiff?
We've used them on the roof of the building in another year. We've used them in another building in the complex on another year, but we never used Zamac nailins for the 2006 work on the water table, period. We were never given them, we were never prescribed them or instructed to use them.
Thank you.
Just very briefly, Your Honors. First of all, the question about the Zamac nail-in, if you look at page 2666 of the record, this was the list of, part of the list for the 2006 work. And on that top of that page, it says raw Zamac nail-in. So to say that there was no Zamac
So
nail-in.
isn't that an issue of fact in itself?
Well, certainly it's an issue of fact with respect to Grenadier, and it's very clear. The other point I'd like to make with respect to the age of the building and all of that, I think that's a red herring, because the point here is that what fell on the plaintiff is not a piece of the original building. So the fact that this was an old building is irrelevant. What happened from a causal standpoint is that a faulty patch is what should never have been put in place in the first place. That's what fell on the plaintiff, and this is what caused this litigation. So all of this smoke and mirrors about the building
Did
being
anyone else
old.
work in that area in the 2006, 2007 period?
No, we have the evidence of 2006 and 2007, including the landmark photos that show clearly that the patch was there. The spall was no longer visible. So that work was done between that time period, and the only contractor that worked during that time period in that area was Grenadier. Thank you, Your Honor.
Thank you all. Peña versus Kokata and Satyanayana. And Justice Gesmer is recused.
May it please the court.
Just one moment.
May it please the court. Joshua Fogel, Sanaki Newman Turret, on behalf of the plaintiff appellant.
Sir, would you agree that the original and only notice to claim that was filed by your client makes no discussion of the nerve block causing any kind of injury to her?
I would agree it does not mention the nerve block.
And the focus of that notice to claim in its totality focused on presenting in August in the emergency room and working her way through ultimately to when Dr. Andelman in October of that year decided we're going to go forward with the ACL surgery, correct?
It did discuss the presentation to the emergency room beginning in August, working through diagnosis of
And that's
ACL injury.
the essence of your
surgery in
claim.
October.
I'm sorry to cut you off. The essence of your claim is that they didn't do a lot of prep work earlier on in terms of MRIs, et cetera, and giving instructions not to use the immobilizer and going about the normal daily activity without certain safeguards that ultimately led to the surgery.
Those are referenced in the notice of claim.
Correct. And then only after the litigation started and your summons and complaint was filed, that you started advancing this theory that after the surgery, when the anesthesiologist performed the procedure to put in the nerve block, that ultimately triggered the various conditions set forth in her leg, correct?
I disagree with that, Your Honor, in that Ms. Peña testified at her 50H hearing concerning the nerve block and the nerve injury that was caused thereby.
Can that testimony cure the notice of claim?
Well, according to the Court of Appeals in D'Alessandro, it's permissible. What the evaluation needs to be is whether the municipality, in this case New York City Health and Hospitals Corporation, has sufficient information as to the place, time, and nature of the claims to investigate and evaluate the merits of the claim.
But this is a substantive claim, isn't it? I mean, you never say anything about the nerve block before. In fact, at the time you file your action, there hadn't even been discovery of this nerve block. And that's the main claim now, is that this EMG discovered in January after you filed that this nerve block was causing all of her issues. So that's a new claim that you're going forward on, and that wasn't raised till well over when the time the amended notice of claim could have been done, almost a year past that. So
Well-
how do you proceed on an amended notice of claim under those circumstances?
I would disagree that it's a substantive change. It's an additional theory of medical malpractice, but they're all claims of medical malpractice, which is what was alleged in the notice of claim. What the Court of Appeals said in
But it's one that couldn't have been, it couldn't have come up from what the original action was. It was just something totally different.
Well, what the Court of Appeals said in D'Alessandro was that the inquiry is not limited to the four corners of the notice of claim. Any error in the notice of claim can be disregarded if there's no prejudice. That the inquiry can include information and evidence adduced at the 50H hearing and other evidence. So this is information that was adduced at the 50H hearing through Ms. Peña's testimony. It's information that was in the summons complaint, the bill of particulars, which were all served and filed in advance of the 1 year and 90-day statute.
Except if you believe, if this is a substantive issue, then 50H hearing testimony can't rectify that kind of deficiency.
And additionally, the defendant's own medical records make reference to the same theories that are alleged in the complaint and what was submitted in opposition to the motion for summary judgment, in that Dr. Andelman, the orthopedist, he included in his differential diagnosis that the nerve block caused this nerve injury. So it's in the defendant's own records. What General Municipal Law 50E says is a correction to an error can be made at any time. The law is clear that General Municipal Law is supposed to be used as a shield against spurious claims and not a sword to strike down meritorious claims. Here, we have expert opinion who sets forth an opinion that the defendants departed from good and accepted medical practice, that departure was a proximate cause of injuries. It's clear that the claim has merit. The case should be decided on the merit. The defendant had noticed there's no prejudice. Plaintiff's expert in his affirmation submitted in opposition to the defendant's motion set forth an opinion that the defendant's own records gave them notice of these claims. The records say it. The doctor, Dr. Andelman, in his differential diagnosis included this. The defendants have not come forth with any evidence of prejudice as to the claim regarding the nerve block. Hoffman versus New York City Transit Authority says prejudice is not to be presumed. Wade versus City of New York says if it's in the record, there can be no prejudice. Avery versus New York City Transit Authority and Norrie versus City of New York say it's an abuse of discretion to deny a motion to amend a notice of claim where there's no showing of bad faith or prejudice. Under these circumstances, either the motion to dismiss should have been denied or our cross motion to amend the notice of claim should have been granted. Once that was done, it's clear there were questions of fact regarding the experts. It's a classic battle of the experts. Summary judgment should have been denied.
Thank you.
Thank you.
Ian Sinclair, Ian Sinclair with New York City Law Department for respondents, and may it please the court. As the justices have pointed out, the complaint that Ms. Peña filed and the claim she now pursues on appeal are premised on fundamentally different theories of liability. The original notice is unambiguously focused on improper clinical and diagnostic treatment that exacerbated her the knee injury she suffered at home, causing the ACL rupture and ultimately to need ACL reconstruction surgery. Her complaint largely abandoned that theory, asserting instead that the surgery itself and now a post-operative anesthetic damaged her left femoral nerve. For that reason, Supreme Court properly concluded that the original
Wasn't
notice—
that something that everyone was on notice of and knew about anyway? I mean, not formal notice in this proper way, in the legal way, but the hospital knew, the doctors knew, it's the same patient. The doctor actually, told her that he would have to stop treating her because this would have been part of the claim. because I think this was, the notice of claim was filed December 8th, 2020, and then the EMG was not filed, didn't happen until January 13th. And I think the doctor who was involved stopped treating her at that point. Wasn't everybody aware? Is this prejudicial?
Well, Dr. Andelman stopped treating her because he left Lincoln Hospital, so it wasn't related to the litigation as far as I'm aware. But they were not on notice that this was going to be the focus of her litigation. She very clearly articulated a theory about the improper clinical and diagnostic treatment. She had dozens of appointments at Lincoln Health and Hospitals outside of the nerve block even. There was the manipulation under anesthesia in mid-December and post-operative treatment after that.
I'm sorry, in fact, shortly after the surgery, when she went to Dr. Endelman post-operatively, she was functioning.
Yes, she had
At least 5 days later, it was working.
the nerve was her quad fired until late December.
Could you address the prejudice?
Just let me ask, you're right, it did fire right afterwards, but that's why the doctors recommended the EMG, because something was wrong. They saw that something was wrong, and that's why that took place in the beginning of January, right?
Yes.
Okay.
Sorry, and on the issue of prejudice. So, yes, first is just that prejudice is a conjunctive element within E6. It's not a separate pathway to amend a notice of claim. You still have to show, as your justices were discussing earlier, that the amendments do not substantively alter the theory of the claim or the theory of liability, which is the case
And would the
here.
amendments here change the nature of the claim?
I'm sorry?
Would the amendments here change the nature of the claim?
I think they do. If we look at Mosley or Castillo, in Mosley, they generally alleged inadequate security led to the decedent getting shot, but they more specifically alleged that negligent maintenance of lighting caused unsafe conditions. When the time came to file their complaint and bill of particulars, they shifted theories and focused on inadequate CCTV cameras and inadequate policies protecting residents from criminal activity. And the court said, this is a new theory of liability. The tortious conduct has shifted. It's no longer about the original claim. Similarly, in Castillo, the original notice of claim was about related to a hip surgery and allegedly a negligently inserted catheter during that hip surgery. When they came to file their complaint and bill of particulars, they shifted focus to a distinct injury, femoral nerve damage that took place during the same hip surgery, but still it was outside the notice of claim because it was a new independent injury premised on a new theory of liability.
There's also another independent claim for lack of informed consent.
Right, so there's
was
an
not-
entirely new cause of action, which is generally just outside the scope. To the issue of prejudice, I think generally Wally G is clear that the medical records must do more than suggest evidence of malpractice. They have to evince or reveal it. And a comprehensive reading of H&H's records don't suggest that there's any malpractice. There's no aspect of the nerve block procedure indicates that anything went wrong. There's nothing that suggests that the needle didn't penetrate, like a description of the ultrasound. They didn't experience high pressure when actually injecting the anesthetic, which would have been felt if the needle had been in the nerve. So there's besides Dr. Andelman's notes, really, there's where he's speculating about a range of theories, which only get more complicated over time. There's really nothing to suggest that something went wrong, and the standard has to be higher than that.
You can end if you
Yeah,
like.
if there are no more questions,
You don't have to use all the time. Okay, thank
I
you.
will submit and ask this court to affirm.
Just briefly, returning to the issue of prejudice, even after counsel's argument, I still haven't heard any clear statement as to what HHC's prejudice here. The doctor was available. He was represented by counsel. They were able to speak to all these people. There's no records that went missing or anything like that. So any passage of time certainly did not cause any prejudice. There was a initial presentation of Ms. Peña to the hospital for follow-up appointments where her quad was functioning. There was a deterioration of time. Plaintiff's experts opines that's consistent with an intraneural injection, which would cause a compartment syndrome, scarring of the nerve, which would cause a progressive condition. When she's there in December 11th, there's a decreased range of motion. She undergoes a manipulation under anesthesia a few days later. When she's back at the end of December on the 28th, the quad is, quote, not firing. That's when the EMG is ordered. The reason why she stopped treating with Dr. Andelman, while he did leave the hospital, but before that happened, he referred her to Dr. Kohler at Downstate because he's a specialist in this condition. He operates on nerves, which is not something that Dr. Andelman does. With regards to the Castillo case, it's totally different here. That was a case where the notice of claim alleged that a Foley catheter was improperly placed intraoperatively, and then subsequently the claims alleged regards nerve injury to the thigh. Here, all the claims are involving the treatment to the plaintiff's knee. It's wholly consistent. It's not a totally different body part or procedure like it was in Castillo.
Was it put into her knee? Was the nerve block wasn't put into her knee?
Well, it's to the femoral nerve, which is all part of the knee surgery.
Well, in that case, it is more like Castillo, isn't it?
I disagree.
Not put it into the
I
hip.
don't see it that way. I think that would require something very specific. The Desai Young versus HHC case specifically says a notice of claim, we don't have the same burden as a pleading. So general claims are sufficient in a notice of claim, and that's why what was said in the notice of claim is sufficient to put the municipality HHC here on notice of the claims which are set forth in that plaintiff's expert opinion.
Thank you.
Thank you, Your Honor.
Thank you both. Appellate Inc. versus WebMD Health.
Good afternoon, Your Honors. Jeffrey Mitchell for the appellant WebMD Health Corp. I'm with the firm of Ellis George. WebMD guaranteed the payment and performance obligations of its subsidiary under a commercial sublease with the plaintiff Kaplan. A guarantee is a contract of secondary liability, meaning if the subtenant ultimately failed to pay rent, interest, or late charges billed by Kaplan before the underlying motion is heard, or if the subtenant ultimately paid all rent, interest, and late charges billed before the motion was heard, WebMD cannot be liable as a guarantor.
Well, this is an unconditional guarantee that was signed.
Correct.
And it was signed for the payment of money, the rent, and it was signed for performance. Can there be no unconditional guarantee that is, or I should say, can there be no 3213 relief here if there is the joint payment plus performance?
That's correct. And the way it works, Justice Schulman, you were in the I-payment case, which was, I think, become a seminal case in terms of splitting the payment and performance and whether it can be split. And at the last paragraph of that case, you say, the defenses in that case were a warranty of habitability defenses, things that went to something that was a non-performance type conduct. But it says such defenses are not available to defendants because all defendants under the guarantee, with the exception of prior payment, were waived. So let me say to the court, if in this particular case, if the January rent had not been unpaid, and there's a story as to why it was unpaid, but at the end of the tenancy, all rent was paid. But let's go back to January. If the January rent was paid, but there was a dispute over the performance obligations of the subtenant, there's no way that Kaplan could get summary judgment in lieu of complaint without first establishing that the subtenant was obligated to perform the work that is being sought. It doesn't change the case that after the fact, after sending a bill on May 8th, 2024, several weeks or a couple weeks after WebMD vacated the premises, for all rent, late charges, and interest, and that amount gets paid simply because Kaplan took some money and applied it to disputed work, doesn't turn this into a rent dispute. What Kaplan would say, and I would say to this court sits, obviously, a very respected court in New York City with a lot of landlord-tenant cases. If the rule becomes that it's up to the landlord to decide whether you owe me money, and I have the right to take money from a tenant for disputed performance, disputed work, and then charge the subtenant before I've established against the tenant itself that the tenant has to do that work, that creates a whole, I would open a can of worms with, you can think of all the unscrupulous landlords in New York who are going to be suing guarantors and just taking money from security deposits or rent. In this case, it's also not just a case of there's a claim or a dispute that's made up. We provided the court below with a substantial record of proof of why that work was not required. What is not in dispute in this case is that the letters that were sent by the landlord originally, and that Kaplan 1 year before, originally 2017, and then in 2023, a year before WebMD vacated, it had a list of work that was required. There's no dispute that all the work listed was performed. So the question simply is, Kaplan argued, well, you have to do more work because the landlord wanted more work, and rather than defend, as it was its obligation under Section 6 of the sublease, rather than defend WebMD's right to be limited to the listed work, Kaplan instead started threatening WebMD with holdover penalties and other things if it didn't do everything they said. So I don't know, we have no discovery. It's a summary judgment in lieu of complaint. I can't tell you why Kaplan decided to do this work that's not listed, but if you would guess at what I'd like to find out is why they did it and why they simply didn't go back to the landlord and say, you only listed this and all that work was performed. So we have a situation here where you can't get around the idea that this disputed work is at the heart of this case. And that disputed work is not a claim for money only. It's not appropriate for summary judgment in lieu of complaint. WebMD should be entitled as guarantor to assert its defenses, to gather the evidence. And mind you, there are 2 other cases pending. There is a case already pending in light of this decision by the subtenant against Kaplan for stealing a security deposit based upon the decision of the other court, and another case brought by summary judgment in lieu of complaint by Kaplan against WebMD for more money. So Kaplan's goal here is we want to be able to get money from the guarantor, never have to provide any discovery with respect to the work that was performed, and hold the guarantor liable. Let's say the subtenant wins its case against Kaplan, and this court has affirmed this decision based on this record and a very paltry decision from the lower court, and now the subtenant wins. You've already collected something that the subtenant wasn't obligated to pay from the guarantor. Think of all the litigation we have to do. Instead of just sending the whole case back, have it all decided in one proceeding, join it all together, and let's find out who's right. That's really what this case is about. And the argument that Kaplan makes is simply, well, we have a right under the guarantee to call it whatever we want to call it, and we can take this disputed money from the pool of funds that were paid, call that rent, and go after the guarantor for rent, even though we know the shortfall is exclusively from the work they performed that is disputed, and not only disputed, but in the record disputed with evidence. The other thing I would say to your honors is one of the legal issue with respect to the guarantee. There is a top line issue. If I understand I-payment correctly in the cases that follow I-payment, it is not that automatically a guarantee with a performance obligation is void, but it can be under certain circumstances, and this is one of those guarantees, and even in fact, the performance guarantee is invoked by the claim brought here. Thank you.
Thank you.
Your Honors, Janice McAvoy from Fried Frank on behalf of the respondent Kaplan ID.
Counsel,
Sorry, Kaplan.
3213 in lieu of a complaint is usually for when there are no issues and it's money only. Here, there is an unconditional guarantee, but it's for money combined with performance. And it seems like the money aspect of it has been paid, but the performance issue is open.
Your Honor, there are 2 separate disputes here and 2 separate lawsuits. And my friend has spent all of his time trying to mix those 2 separate lawsuits together. There is there's the first lawsuit, this lawsuit, where Kaplan sued a guarantor for the rent. Separately, Kaplan took the security deposit.
Part of the claim for rent that Kaplan's suing for based on the work that was or was not supposed to have been performed?
No, absolutely not, Your Honor. There was $3.5 million in unpaid rent.
It
was
wasn't
a separate-
$818,276.40
That was the first
With-
month.
with plus interest and attorney's fees?
That was the first month, but they continued to withhold rent over time. So by the time we got to summary judgment in June, we had filed in the beginning of February for January rent. By the time we got to summary judgment in June, the amount was $3.5 million. We did not amend our complaint. We were simply seeking that first month. However, in the interim, there was a separate, in addition to the $3.5 million in rent, a separate claim for $1.7 million in restoration obligations.
So you're saying that they
that-
paid you 1.7 for the rent, and then you drew down the guarantee, and
Letter of
all of
credit.
that went to the 3.5 for the rent?
No. So, Your Honor, we separately drew down on the security deposit, and it's really important to separate that out because the security deposit is the subject of that separate lawsuit where it's absurd to say that the subtenant has no claim. The subtenant, WebMD LLC, has sued Kaplan for return of the security deposit in that separate lawsuit.
But did you apply the 1.7 to rent?
There are two 1.7s. It gets a little confusing. So we applied the 1.7 million payment from guarantor to rent. We applied the $1.7 million security deposit to the restoration obligation. And that we are entitled to do under both the lease and the guarantee.
But doesn't that raise issues of fact?
Not
If they
at
say they've paid everything?
They say, we've paid everything because Kaplan, you should apply the security deposit to rent. But that is not their right. Under both the sublease and the guarantee, they've waived that claim. Under the sublease, they say, they agreed, Kaplan has the right to apply payments made by tenant to any items as it sees fit, irrespective of any designation or request by tenant. Tenant can say, oh, I'm giving you this money, you have to use it in this order. Landlord gets to decide in what order it uses it. So landlord used the 1.7 million payment from guarantor to apply to rent. I hate it that all these numbers are the same, right? Leaving 1.7 million unpaid. It then used the security deposit to hold for itself in connection with the restoration obligations, which were also 1.7 million. And importantly, the guarantor waived any claim to say, well, there's an offset for the security deposit. Under the guarantee, in no event shall any amount payable by guarantor pursuant to this guarantee be reduced by the amount of the security deposit held or applied by sublandlord under the sublease. The parties acknowledging that such security amount may be applied by sublandlord in its discretion in accordance with the lease, and this guarantee shall not be impaired, affected, or reduced by virtue of any release or application of the security amount pursuant to the sublease. So there is a separate lawsuit
So,
where
counsel, I'm listening to you, and you keep throwing me because it's a letter of credit and not a security deposit. I mean, I don't want to get technical about it. But my understanding is that there was a payment of $1.7 million, and then you drew down on a letter of credit here, which is, you correctly state, could be used for whatever purposes. Their issue here is that if you had taken the letter of credit together with the 1.7, there would be no outstanding rent. But what you did was you used it to pay back for the so-called work to make it a white box or whatever you wanted to make it into, which they take issue with because they claim everything was taken care of and you had no right under that factual scenario to do so. So let me finish the thought and then you can answer. While you have the right to do what you do under the guarantee, to take it for whatever purposes. The question is it justified, and can they raise an issue of fact as to whether what you did contractually was appropriate under these circumstances? And that, to me, leads to their position that you're not entitled to 3213 relief, but it's a question of fact.
So, Your Honor, the letter of credit is in fact a security deposit.
No, I know
It's
that.
called the security amount, the security deposit. It could have been posted as a letter of credit or cash. It is the security deposit. And this court held in 501 Fifth Avenue against Aslam that where there, the landlord kept the security deposit and said, I am going to keep this security deposit and use it for after the tenant moves out in case I have any damages. Exactly what Kaplan did here, exactly. And the court said that against the guarantor, the landlord was still entitled to collect the full amount of the rent owed without any offset from the security deposit because the guarantor had waived that and because the security deposit claim is a claim that is personal to the subtenant. And now the subtenant has sued in a separate lawsuit that's a plenary action where there will be discovery as to whether or not it was appropriate to apply the security deposit to those restoration obligations. But that's a dispute between the subtenant and Kaplan, a non-party to this lawsuit. What Kaplan bargained for, what guarantor agreed to, is we will pay the rent without offset for other claims that the subtenant has and without offset from the security deposit. And now they're saying, no, you have to offset the security deposit against my liability. You have to take your security deposit and apply it to rent. But both the lease and the guarantee are crystal clear that that's not allowed. They are not allowed to tell the landlord what to do with the security deposit. They can, and they will pursue the separate lawsuit for seeking return of the security deposit. But again, that's between the subtenant and Kaplan, not the guarantor. And when they agreed in the guarantee that they would guarantee the amounts of rent without offset by the security deposit, that's enforceable. This court has repeatedly held that such waivers are completely enforceable. 501 Fifth against Aslam is one exactly such case. There's no dispute here about the amount of rent that wasn't paid. $3.5 million wasn't paid. The only thing that's in dispute is what Kaplan should have done with the security deposit.
Thank you.
That's a claim for the subtenant, not for the guarantor. It was waived by the guarantor.
Thank you.
Counsel, can you respond to her waiver arguments?
Absolutely. Let's talk about, it follows up on what Justice Schulman is saying. There is a bill sent by the landlord, by Kaplan, on May 8, 2024. It's at R461 of the record. It's in the amount of $3.5 million, and it expressly says it's for all past due rent, additional rent, late fees, and interest. 1 week later, Kaplan drew on the letter of credit. At that moment, it hadn't even completed whatever work it was performing in the premises. So the only thing due at the moment they drew on the letter of credit was rent, because nothing else was due yet. I don't even know if they'd paid a contractor. We haven't had any discovery yet. So at the moment they take the security deposit, all that they can be taking the security deposit for properly is rent, because that's all that was due right then. All that else that existed is whether the work that Kaplan was still performing in the premises, whether that was required from the subtenant, and we showed the court that it was not required from the subtenant. So when WebMD wires, when the subtenant wires a week later, $1.7 million, the only thing that money could be used for properly at that time was rent. Kaplan cleverly tried to grab the money first. Let me take the money first. We're doing work in the premises. $1.8 million. By the way, we also have in the record proof that at the time they only estimated the work they were doing is $800,000, not $1.8 million. But they grabbed the entire security deposit and then claimed there's a rent shortfall and go after the guarantor. All of this is tied together. This is a commercial lease. This is an end of commercial lease dispute. The subtenant performed $3 million worth of restoration work.
Do you disagree that they were able to take the guarantee and apply it to the back rent? I mean, if it wasn't, what you just said was that there was only one thing due at the time. It was the rent. And so
It could only be one thing due.
there was, that's right, it was the rent.
Yeah.
So their position is that they were able to take the guarantee and apply it to the rent.
No, it's not the guarantee, it's the letter of credit.
Letter of credit.
They're
I'm
saying
sorry.
they did not apply it to the rent. They applied it to still being performed obligations, they say, of the subtenant, which we proved, I thought we showed below. The subtenant had good faith defenses to why it didn't have to perform that work. At the end of the day, Kaplan can only be paid once, right? You get paid one time. And if Kaplan's not entitled, it's a fact. If Kaplan is wrong about this extra work, and that it performed the extra work on its own dime for whatever reason, then it's been paid in full. It's a fact they've been paid in full because they sent a bill and the bill was paid. For whatever reason, and it's, unfortunately, summary judgment is a de novo review in the appellate court. We do not have a reasoned decision at all from the lower court. So we don't have the benefit of the court's thinking. We don't even have any of this discussed in the decision below. But it certainly feels like a case where the performance obligation is tied into the payment obligation of the guarantee, and it's not simply a waiver of defense case. It's that you don't owe the money. Since a guarantee, I started with a guarantee is a contract of secondary liability, unless the tenant really was liable for that work. How can the guarantor be called on the guarantee to pay for it? That has to come first. So at a minimum, the subtenant's case has to be decided first.
Thank you. Thank you both. People versus Bryant Bijou.
May it please the court. Sarah Stevenson Peck from the Cornell Appellate Criminal Defense Clinic on behalf of Bryant Bijou. I'm here with my supervisor, Alexandra Metter. The lower court erred in denying a missing witness instruction for Detective Ortiz because he had two pieces of material non-cumulative evidence that the jury should have heard: the impeachment of Mr. Wright and his perception as a special victims unit detective and the only person who spent significant time talking to Mr. Bijou about his mental state. First, the impeachment of Mr. Wright. Eric Wright, the Good Samaritan, credibly testified that he did not hear Mr. Bijou muttering at the scene. This called into question Officer Conlon's conflicting testimony that Mr. Bijou was muttering. That created a problem for the jury because they can't believe both.
Well, I don't know. I'm not convinced they can't believe both. I mean, some people, a person may have heard muttering, another person may have not heard muttering at the same time. It was on a public street. One person may have heard it, one person may not have. It doesn't mean that one's lying and one's telling the truth. They perceived it differently, correct?
That's right, Your Honor.
Isn't that a possibility?
It is, but in this case, all parties agreed that Eric Wright did speak to Detective Ortiz the day of the crime and say that he did hear Mr. Bijou muttering. So in this case, his testimony on the stand was incorrect.
Wasn't it a couple hours before Detective Ortiz spoke to the defendant? Wasn't there a gap of a couple hours?
Yes, there was. That certainly doesn't have bearing on the fact that he could have impeached Eric Wright through prior inconsistent statement. The impeachment would have mattered because if his testimony, his undisputed testimony, called into question what Officer Conlon said, it discredited Officer Conlon as a witness. And Officer Conlon was a critical witness for the defense's theory that Bryant Bijou was under the influence of drugs and not acting for his sexual gratification. Officer Conlon testified and was the only witness that testified that he heard Mr. Bijou muttering.
Are you saying that those two things are mutually exclusive? That if he was acting under the influence of drugs, he couldn't have been acting for sexual gratification?
Not necessarily, but the defense's theory in this case was that he was acting under the influence of drugs and not for the purpose of sexual gratification.
But there's no evidence that the defendant had recently used drugs. 3 witnesses testified that they believed the defendant was sober, and the defendant didn't request an intoxication charge.
The evidence in the record had to do with the syringe that the police did not test that was found on his person, and with the witnesses, specifically Officer Conlon, testifying that he believed Mr. Bijou was acting in a number of ways that seemed odd. The muttering, fidgeting with a lighter, walking calmly away from the police, looking away when asked his name, as well as the video in this case. And that brings me to my second point about how Detective Ortiz was the person who was best suited to testify to Mr. Bijou's mental state because he was the only one who spent significant time talking to the defendant. As the lead detective on the case, Detective Ortiz had the opportunity to speak to the defendant, Mirandize the defendant, and was the only person who spoke to the defendant who was trying to figure out what was going on with the case instead of actively trying to
Finish your sentence.
actively trying to mitigate the situation on the ground.
So Officer Ortiz, I think, was the only person who wasn't at the scene. So he didn't actually see what was happening. That could be why he was spending time speaking to the defendant to find out what happened. But there were eyewitnesses there, people who intervened. There's the video. So there's no question, it seems, about the sexual gratification and whether or not, even if he was under the influence of drugs, that there wasn't the issue of sexual gratification.
Well, it's hard to tell what his intent was just from observing the behavior. That the eyewitnesses could have spoken to the actus reus, but somebody who spoke to Mr. Bijou would be best suited to talk about the mens rea in this case, because he got a better view of what was going on in Mr. Bijou's mind than did the witnesses who were on the scene, who didn't speak to Mr. Bijou about the incident.
Well,
I mean,
I'm sorry.
go ahead.
The victim herself had her own perceptions of her attacker, your client. And she didn't perceive him to be under the influence of anything. She had a right. I mean, her perceptions were real time right at the time. Correct?
That's right. She did testify that way. I would contend that her perception, she was obviously a little busy at the time, and that the perception of somebody who actually spoke to and was trying to understand the defendant would be better suited, material evidence that would have made a difference in this case.
May it please the court, Assistant District Attorney David Crowley for the people. On the missing witness charge issue.
People, I just want to ask, Detective Ortiz never responded to the scene?
That is correct. And that's
Didn't witness the offense take place, correct?
also correct.
And didn't see the immediate aftermath of the assault, correct?
That is correct. The evidence, as far as we can tell, at 3:15, the interview, the discussion he had with the defendant was a statement that the defendant made, "I plead the fifth and I want a lawyer." That's it. That's the entire extent, and it's hours later. We have no idea what, if any, other interaction he ever had with the defendant. So
Is there no evidence of muttering, of him recording that the defendant was muttering?
Detective Ortiz did not witness him muttering for all the reasons that he wasn't there. He didn't respond to the scene. I think
No, after in his discussion, or anything that was said after, when when Detective Ortiz was with him.
the record suggests that the Good Samaritan, Eric Wright, who had testified at trial, he did not recall the defendant muttering, that he had a telephone call with Detective Ortiz that night where he had told Detective Ortiz, "I heard him muttering." Now, first of all, this is not a material issue, right? You can commit a sexual assault with the intent to gratify your own sexual desires and still mutter at some point. More to the point, it didn't conflict with Officer Conlon because Eric Wright observed the defendant during the attack. Officer Conlon was responding. It is possible that he was mouthing something when Officer Conlon saw him and not muttering. So there's no conflict there. And I think for a missing witness charge, the key issue is the people cannot call a detective to impeach their own witness when the witness has testified favorably for the people. That's CPL 60.35. We just can't do it. And even if we wanted to, even if Eric Wright had testified unfavorably to us, we could only introduce a prior inconsistent statement through the detective if the statement was...
Well, you could have done it. Maybe there would have been an objection. I mean, it's not like it hasn't been done before.
I suppose we could have done it without objection, but I think the point is it is not something that the people had some strategic reason for not calling him, right? We had 3 witnesses, unrebutted evidence of 3 witnesses who said this defendant did not appear to be under the influence of drugs. We had a slew of officers who observed the defendant and dozens of witnesses before Detective Ortiz has any involvement in the case. If Detective Ortiz is required to comment about his observations of the defendant and what his opinions were, or whether he did or did not hear somebody else refer about muttering, potentially we would have to have called all those other officers who were securing the defendant at the scene and with him for, I think, around 10 minutes. Officer Conlon's partner who transported the defendant back, who helped do the processing and searching. There are any number of witnesses who would have been better suited than Detective Ortiz to add to this picture, but none of them were necessary because we presented overwhelming proof of the defendant's guilt.
Did the defendant have an opportunity, did the defense attorney have an opportunity to raise this issue on summation?
Yes, and she did. She said that it was unacceptable that the people had not called Detective Ortiz, and she also made references to Officer Conlon's failure to voucher the syringe. All of the arguments that they suggest that they wanted to make through Detective Ortiz, counsel was allowed to make in summation, and the court also permitted the defense to call Detective Ortiz had the defense wished to do so. And so even if there had been some error in the failure to issue the instruction, I submit it would have been harmless because there's no significant probability that simply giving the instruction would have led to an acquittal in this case. Thank you very much.
All parties agree that Detective Ortiz could have given non-cumulative material testimony in the form of impeachment of Mr. Wright. That's not in dispute, and the law does not have a de minimis exception for the missing witness standard. Although Detective Ortiz was not on the scene of the crime, he was the lead detective in trying to piece all of the witnesses, stories, videos, etc. together to figure out what had happened. Since he had also interviewed the defendant and was the only person who spent significant time talking to the defendant, that makes his testimony probative and unique. He had a different perspective than did the witnesses who were at the scene of the crime, especially considering that they were busy managing the scene of the crime, while Detective Ortiz had an uninterrupted opportunity to speak to the defendant. Although he couldn't have introduced the statement, I plead the fifth and want my lawyer. The defendant acted non-verbally, and there was a process of Mirandizing the defendant, all of which he could have spoken to. Thank you.
Thank you. Did I understand that you are a law student or a law student? And where are you studying?
At Cornell.
Wonderful. You did a great job. Not that you didn't, but I think she deserves that. Black versus Geneva. You may begin.
Thank you. Good afternoon, and may it please the court. My name is Max Gershinoff. I'm here for Defendant Appellant Wigdor, LLP. I'd just like to start by saying that the action that brings us here, the malicious prosecution case that brings us here today, is clearly an action involving public petition and participation within the ambit of New York's amended anti-SLAPP statute. It's based on fundamentally my client Wigdor, which is a law firm, its representation of its client, Ms. Ganieva, in a sexual assault and defamation case against a prominent multi-billionaire who himself contends that he's the father of the alternative asset industry, who is or was a leading philanthropist, and so on and so forth. It's against that backdrop, it's obvious that this case didn't involve a purely private matter. And because this case involves public petition and participation, fundamentally, when the Supreme Court assessed our motion to dismiss, it should have assessed it and applied the standards under CPLR 3211G. But it didn't really apply those standards. It didn't require the plaintiff, Leon Black, to come forward with any evidence at all beyond the conclusory and at times inherently contradictory allegations in his complaint. And I understand that the standard for adjudicating a motion to dismiss under 3211G has been stated differently since the amendments to the anti-SLAPP statute in recent years. Some courts seem to have required plaintiffs to show clear and convincing evidence to support their claims at the pleading stage. But last August, this court in Reeves versus Associated Newspapers clarified the standard somewhat. And it said, in substance, you've got to, at the pleading stage, it's not the usual standards on a motion to dismiss under 3211A. Okay, you might not have to come forward with clear and convincing evidence to support your claims, but you've got to come forward with some evidence. In Reeves, this court said it was akin to an accelerated summary judgment motion where the burden is shifted to the plaintiff. It contemplates the submission of affidavits by the plaintiff. If the plaintiff needs...
Were there any affidavits submitted in this case by the
No,
plaintiff?
Your Honor, there weren't. And quite like the situation that was presented in the Reeves case, instead, the plaintiff contended that the amended anti-SLAPP statute didn't apply, and he didn't really contend with the standards at all. The only thing that was submitted in opposition to our motion to dismiss was a memorandum of law signed by counsel. There were no affidavits submitted. There was no proof submitted beyond an unverified second amended complaint, the allegations of which were variously conclusory, inherently contradictory, and in some cases made no sense. And what happened here was the Supreme Court essentially declined to really apply the 3211G standards under the anti-SLAPP statute to our motion to dismiss based on a determination that the anti-SLAPP statute did not apply because there was no case law applying the anti-SLAPP statute to malicious prosecution claims. But that's hardly a surprise considering that the anti-SLAPP statute was very recently amended in 2020 to substantially expand the ambit of its protections. And in fact, as this court has noted in prior cases, the purpose of the amendments to the anti-SLAPP statute were to remedy the overly narrow interpretation the courts had been giving to the existing anti-SLAPP statute. So the court didn't really apply the anti-SLAPP statute to this case. It didn't apply 3211G. It didn't require the plaintiff, Mr. Black, to come forward with any evidence at all to support his malicious prosecution claim. And instead, what the court did was it assessed the complaint under 3211A7 by accepting the allegations in the complaint as true and giving them the benefit of every favorable inference, which was erroneous. And it had substantial downstream effects. Because let's be clear, this is a malicious prosecution claim against a law firm that represented Mr. Black's adversary in a prior unsuccessful case. And by failing to employ the heightened standards applicable under 3211G, there were substantial negative downstream effects. For example, instead of requiring Mr. Black to show an entire lack of probable cause for the prior unsuccessful action, the courts basically found that just because the prior action had been dismissed at the pleading stage based on a release, there was no probable cause. But there's plenty of cases which stand for the proposition that you have defenses to releases that you can raise. And in fact, in the prior unsuccessful case, the plaintiff, my client's former client, appealed to this court. And although the dismissal of her prior case was sustained, there was a strong dissent. At least one of the judges on the panel would have, reversed and allowed the prior unsuccessful case to become a successful case, or at least to proceed in court, which underscores why there was not an entire lack of probable cause for the case, a patent lack of probable cause at the case's inception. Malice, also, there was no evidence presented to actually show that my client, a law firm, acted with any malice. It was just, basically through conclusory statements. I see that my time is up, so I will...
Thank you.
Yeah.
May it please the court. I'm Jennifer Barrett from Quinn Emanuel here on behalf of plaintiff respondent Mr. Leon Black. As a threshold, my friend Mr. Gershinoff is incorrect that the motion court failed to consider the standard, the substantial basis in law standard from CPLR 3211G. While the court noted that defendant had failed to raise and meet their burden for proving that this case is applicable under the Anti-SLAPP Act, nevertheless, in an abundance of caution, the court went on to consider that standard.
But then how did they satisfy it if, in this case, there was no affidavit, there are no letters in support? I mean, there's nothing here that would have satisfied 3211G.
So that is actually inaccurate. The court noted the substantial basis in law standard from 3211G, noted that—
Was there an affidavit from Mr. Black?
There was not an affidavit from Mr. Black. However, what the court did have before it, and if Your Honor will recall, this is a case where the motion court has presided over both this case as well as the underlying
That
case.
doesn't create a record of fact by the individuals involved. The court can't just consider miscellaneous things it's heard along the way. And in the absence of an affidavit by Mr. Black, what established the basis for 3211G?
In a malicious prosecution case, we would submit that the court actually does have to consider the record on the underlying case, because one of the elements that the court needs to consider in assessing it either under 3211A or 3211G is whether or not there was an absolute absence of
What
probable
document
cause.
are you saying established that?
So the documents that established that, which were before the district court, were the undisputed
For the
documentary—
district court?
Pardon me, Your Honor, before the trial court. I am conflating my courts. The undisputed documentary evidence of the NDA release agreement, which was before the district, before the trial
But
court.
that document really says that even if Ms. Geneva had a valid basis to prosecute your client for sexual abuse, et cetera, the NDA blocked it. It's like a release. It wasn't a merit-based analysis. Justice Cohn didn't do a merit-based analysis when he dismissed the case, and the appellate division didn't do, while the dissent went into suggesting coercion or duress in the signing of the NDA, in affirming Justice Cohn in that decision, we just simply say the NDA precludes the lawsuit. That's not a finding that there was absolutely no probable cause that should have been developed on this record to justify malicious prosecution.
We disagree, Your Honor. The presence of a release where a party has fully released claims against another individual is a block to a lawsuit. If a party releases the claims and would otherwise have a cause of action against another party, that party does not have probable cause to bring the cause of action. The release acts as a total bar to the probable cause to bring the other action. The release here was the basis for the underlying dismissal. The release was before the court in this motion as well as below. The court also had before it the undisputed fact that Geneva ratified the release. This court, again, affirmed that. There was one dissent, which is not precedential and not binding in this case. But the court's affirmance, based upon the plain language of the NDA release as well as the ratification, did establish a lack of probable cause. And the courts are—
Also, what case law do you have to support that statement?
Your Honor, courts assessing, and I would like to address the standard under 3211G, but courts assessing the standard under that statute have said that it is possible to find a total lack of probable cause. Excuse me, the courts did not assess that under 3211G, but they assessed that under the malicious prosecution. Under the malicious prosecution standard, a court can find a lack of probable cause based upon missing elements from the claim or a release that bars that claim. And those cases were presented below.
But you didn't submit any supporting evidence. You're saying the court searched the record and found it, but you, on behalf of your client or the attorney below, didn't submit any supporting evidence, no affidavit, nothing, correct?
Your Honor, the supporting evidence was in the record from below. The supporting evidence.
Could you just answer the question?
We understand that your position is with regard to the NDA. The NDA doesn't really get to the heart or the truth of the issue. It says that based on an agreement between the parties, you don't discuss those facts are not dealt with. You're not going to talk about them. What is here is a malicious prosecution that is brought against the individual who released information from the NDA. And as counsel indicated, these cases are supposed to be reviewed as an accelerated summary judgment motion. That means you have to have some basis that goes right to the actual facts. And there's nothing here that can, the NDA can't do that because it never did it in the first place. So what has been presented that goes to challenging the fact of what was actually said by Ms. Geneva in this case?
So what was presented to the district court were cases.
To the trial court.
To the trial court were cases establishing that a release agreement is valid and enforceable.
But you agree that you submitted no factual documentation. I have the record open in front of me. There's nothing, you did not submit anything in response except a memorandum of law, right?
No, Your Honor. Again, I apologize for repeating myself, but the factual documentation was the fact of the release.
I understand. You did not submit any factual documents. You relied on the factual documents submitted by defendants, correct?
The release
You relied on the documents submitted by defendants. You didn't submit anything additional, correct?
Defendants did not submit documents either. We relied upon the fact that the undisputed evidence showed that the case below had no probable cause because it was
Based on the NDA.
Based upon the NDA, based upon the ratification, and based upon the absence of repudiation.
Thank you.
This is not, with all respect, like a defamation case where a court has to assess the underlying truth of a case when it's assessing it under the anti-SLAPP statute.
Thank you.
Just as a threshold matter, contrary to opposing counsel's representations in connection with the motion to dismiss, the defendants did submit
We know.
affirmations and other materials. Other than that, what I would say is this, with respect to leaving aside the anti-SLAPP issues, with respect to the entire absence of probable cause, the mere presence of a release doesn't establish a patent lack of probable cause at the inception of a case. There's lots of cases where a litigant has sued, the defendant has come forward and said, oh no, you released me, and a litigant has been able to prevail based on defenses to the enforceability of the release. In this case, our client wasn't able to do that on behalf of its client, but it came close. Doesn't mean there was a lack of probable cause. At least one of the judges on the appellate panel agreed. So that's the first thing I would say. With respect to malice, the malice allegation.
I keep saying that, and while I respect the most, the one member who agreed, it still wasn't the majority. So.
Yes, Your Honor, absolutely. I would say that that's true, so I'll stop saying it. With respect to...
You can say it if you want, but we have to follow the majority.
Understood. What I'm trying to establish is that, the lack of probable cause has to be patent. And I don't think that here you could say that there was a patent lack of probable cause. The malice allegations in this case were completely threadbare and conclusory. And the special injury allegations in this case were completely contradictory. For example, Mr. Black contended that he suffered special injury as the result of his purported resignation from Apollo as the result of the prior case, but he resigned from Apollo 2 months before the prior case was filed. These are the kinds of things that the court should have unpacked when analyzing our motion to dismiss under 3211G, but didn't. Fundamentally, Your Honors, if the Supreme Court's decision is permitted to stand, it's going to set such a low bar for malicious prosecution claims against attorneys that no attorney could take a case that wasn't a complete sure thing without being afraid of being sued on a malicious prosecution claim based on threadbare and conclusory allegations of lack of probable cause, malice, and special injury.
Thank you. Thank you both. Uni-Rty Corp versus New York Guangdong Finance.
May it please the court, Tucker Bird. I have the privilege of representing the petitioners, appellants, Uni-Rty, which is pronounced, and Golden Pacific, whose founder, Dr. Joseph Chuang, is actually here today. As you can see from the record, this is a 30-year journey for justice. Unfortunately, that journey was derailed when the trial court below, we believe, made several serious errors which justify reversal. So let me go and touch on this. First, with respect to DCL 273A, we think the court erred in several respects. First, we think it improperly failed to shift the burden to the respondents in that case because the respondents were the classic insiders as to the transfers, which essentially gutted the entity, New York Guangdong Finance. I've been saying that for so long it sort of rolls off my tongue. With the classic insiders into the transfers that...
How do you, on this record, during the course of the turnover trial, where was the evidence of record that established that NYGFI was insolvent at the time of the settlements, certainly in 2005 when the Supreme Court and the Texas actions were settled, where you had a federal mediator who determined that there was good faith during the course of that settlement in Texas, and when you had two courts approving the stipulations of settlement that eventually allowed for the payment to the banks, and I'm not repeating the facts. I know you know the record as well as we do. So at this point, I understand you're claiming, but they didn't become insolvent until 2012. But the very acts that you claim violated the D&C law, where was it here?
Well, there are two issues implicated in that question, by the way. First, with respect to the settlement, whether it was a good faith settlement. No doubt that between the perpetrators, they felt like it was a fair deal because they were all getting what they wanted. The missing party or parties from the room in the mediation were my clients or any other outside creditors. So the fact that they had a mediator or a court bless their settlement, it's like asking a student to grade their own papers. I can't imagine a court would say, I'm not going to approve a settlement when all the litigants agreed to it. However, with respect to the solvency issue, which is a great question, it comes up in a couple of contexts in this case. First of all, Mr. Wong, who was the individual that ended up owning basically New York Guangdong Finance, when he was questioned, he said it was probably insolvent at the time of the settlement as a result of it. Moreover, if you dig into it a little further, he said a couple things. He could never identify any assets, any other assets in the entity. And if you remember, Your Honor, his whole purpose was to wind down the entity.
But didn't he, at the settlement, become a 100% shareholder? Mr.
Wong.
Wong, as you said?
All the power was consolidated in him. And if you look at the one thing that the entity did do,
and that was a shareholder of NYGFI.
That's correct. Yeah. That's correct. The one thing that he did do, New York Guangdong Finance did do, is continued to battle with my client for years. Ultimately, they lost the case. I think it's also very interesting that the party that paid for that litigation was not Mr. Wong, was not New York Guangdong Finance, it was the Chu's. So if in fact New York Guangdong Finance had money, why was it having Mr. Chu fund the litigation? It turns out that was basically straw man litigation. So if in fact, take that point, Your Honor, further, if in fact the entity was insolvent, then there's no way, as a matter of law, that the transfer could be deemed in good faith. Moreover, and the courts pretty much say, if you have transfers to insiders, in this case they'll say, well, not one of us was in control, but collectively they had symbiotic control. All the parties that benefited from that settlement were in that room. And they all agreed they got to keep what they took, they had taken. They got to keep what they had been accused of stealing from the company. There was some settlement going back and forth between the parties and the banks where they were paid $7.66 million. And they got to keep everything that they did, leaving the company insolvent. And if in fact it is insolvent, it per se cannot be in good faith on its face. So the issue of solvency, does come up. And I find it interesting when the court tried to justify this, bolster its reasoning, saying, well, there's evidence of good faith here. For example, they said, well, it resolved legitimate claims, that they avoided costly litigation, that they avoided corporate paralysis. But the problem is, all of those were self-inflicted. The very parties that want to wrap themselves up in that settlement agreement, they are the ones that benefited from it, and they are the ones that caused the problem to begin with. You put them all together, the net effect of this, members of the panel, was that New York Guangdong Finance was rendered penniless. There's no evidence, no indication whatsoever of any assets that ever existed after the settlement. And if you want to get right down to it, they even had the one promissory note that they were assigned, that if in fact it was not released, specifically not released. Thank you.
Good afternoon, Your Honors. Victoria Pasculi from Cooley LLP on behalf of the Chu respondents. Your Honors, this is not a journey for justice, as my adversary says. It's a journey for respondents to get finality. This settlement agreement was ratified by 2 courts 2 decades ago, and he is asking this court to unwind a settlement that involved, it was assets all over the world. It was multiple parties, and at this point now 3 separate courts, Texas, New York, and New York, have looked at that settlement and said it was fair, it was reasonable, and it was in the best interest of NYGFI.
Is the claim timely?
The DCL 276?
Was that timely?
So our position is that the trial court correctly held that that claim is time barred. I think first with respect to, I know petitioners have now raised a new argument about whether CPLR 205 tolls the statute of limitations, and our position is first, this court should not consider it because petitioners in their reply brief concede that this is the first time they've raised it, and so I don't think in the interest of justice this court should consider it, but if the court does reach that, then for 2 reasons, the 205 cannot toll the statute of limitations here. By the very terms of the statute, it only applies, or it starts to run after the termination of the first action.
It was a voluntary discontinuance, wasn't it?
Correct, it was a voluntary discontinuance, but in July of 2013. And so the first action was filed in March of 2012. Not a single claim was dismissed until December 2012, but this action here was filed October 2012, so 2 months before any claim was dismissed in that first action. And so 205 doesn't apply for that reason, but also 205 only tolls when it's when you bring a new action based on the same occurrence or transaction. And so here, the first action was a plenary action for damages. There was a claim brought under 276, but the claim did not allege that the settlement agreement was a fraudulent conveyance. It alleged that in March 2006, defendants basically rendered NYGFI insolvent. So to the insolvency, but it's a different insolvency point, but nowhere in the complaint is the settlement mentioned. And so we would say for those 2 reasons, 205 can't apply here. And so as the trial court found, and actually, I think that, there's testimony from petitioner's principal, Mr. Chuang, that he first learned about the derivative lawsuits in 2008 or 2009. So really by 2011, they should have filed their claim. But the trial court didn't stop there. The trial court said, okay, you know, there's this letter, September 2010, and okay, at the very latest, that's when they were put on notice. And so then they had to file their claim by September 2012, and they didn't. They filed it October 2012. And so we would say that it is time barred. So the key question at trial was whether the settlement agreements, again, that were approved by two separate courts 2 decades ago, lacked fair consideration. Fair consideration is a question of fact, and it was petitioner's burden to prove a lack of fair consideration as well as fraudulent intent, and they failed to do so, as the trial court held in a 14-page decision based almost largely on witness credibility determinations. So on appeal, petitioners are now trying to cast their arguments in a way that might be subject to de novo review, you know, injecting these burden of proof arguments, unpreserved arguments about tolling statutes, but really what they're asking at the heart of the appeal, they're asking this court to reverse a verdict that they're not happy with. But again, we keep coming back to essentially now 3 courts have reviewed these settlement agreements and concluded that they were entered into in good faith and for fair consideration. And the court heard live witness testimony from 7 witnesses and found that there was consideration. And so petitioners are asking the court to second guess those decisions, disregard factual findings and credibility determinations made by the trial court, and unwind this incredibly complicated settlement that was effectuated, again, 2 decades ago, involving assets all over the world. And really, we believe that respondents are entitled to finality here, particularly regarding an agreement that was ratified by multiple courts years and years ago. And I just want to briefly touch on the chronology relating to petitioners' federal action and respondents' settlement of Texas and New York actions, because I think that's really important here. Yes, there was a jury verdict in January 2004 before the settlement was ever entered into, but immediately after that, the judge in that case, Judge Sprizzo, essentially invited the defendants to move for a new trial because he thought that the verdict was against the weight of evidence. And so, of course, the defendants did so. And that motion was pending when the parties in Texas entered into this mediation, which, by the way, was court-ordered. It wasn't orchestrated to get around this federal judgment that wasn't even entered. But so the parties in Texas then reach a settlement in October 2004. 2 months later, in December, what happens? Judge Sprizzo vacates, vacates the jury verdict. And so by the time that Mr. Chu and Mr. Wong are negotiating the New York part of the settlement, now we're talking February 2005, there is no jury verdict in effect. And so, and at that point, there's not going to be another trial until July 2009. And then the judgment isn't entered until May 2012. Oh, I see my time. Thank you.
I think we know what happens after that.
Good afternoon, Your Honors. My name is Jacqueline Chang. I represent respondents Agricultural Bank of China and China Construction Bank. Now, the court is familiar with the facts of this case, so I'm not going to go through the record again, but I just want to focus the court on the fact that for the banks, the transaction at issue is a payment of $7.6 million that they received in the settlement of the Texas action and the New York action. That is the money that the petitioners are claiming was a fraudulent conveyance from NYGFI. Now, as counsel has already explained, counsel for the Chus has already explained, there was fair consideration for that transfer. The banks actually relinquished more than $7.6 million worth of assets. They gave up $17.5 million worth of loans, and they gave up all of their equity in the corporation. And they thought at that time, in 2006, that they had exited a failed investment in NYGFI, only to find out 6 years later that petitioners are claiming that this court-approved settlement that they relied on, that they trusted was somehow a fraudulent conveyance. This is not supported by the record. The trial court correctly found that there was no clear and convincing evidence of fraud, and that decision should be affirmed. Now, a couple of responses to points that counsel made here. This idea that the burden on fair consideration should be shifted because this was an insider transaction. That could not be further from the truth. Look at the witness testimony from counsel for the banks. Gregory Brown, he was a partner at Aiken Gump who represented the banks in the Texas action. He testified that the banks brought this litigation because they had no insight into the operations of NYGFI. They didn't even have access to books and records. They had no idea what was going on, and this is also confirmed by real-time reports that representatives of the banks who were sent from China to go work at NYGFI were reporting in real time back to the head office. This clearly was not a situation where the banks were insiders in terms of the paperwork. They were only minority shareholders, and in terms of what was actually going on there. So there's no reason why the burden should be shifted, and that's also a reason why the banks had legitimate claims that they were trying to settle in good faith. Also, this idea that petitioners were not in the room at the time of the settlement. As counsel has already ably described, petitioners had no reason to be in the room in 2006 when these parties were trying to settle this action on behalf of the banks. Petitioners didn't have a judgment yet until 2012. They didn't have standing to object at any kind of legal proceeding in front of Justice Ramos, who was overseeing these proceedings. And there was no reason why these petitioners should have been in the room to settle this action, which was between NYGFI's shareholders. Now, the other issue I want to make about good faith is, the other point I want to make is, yes, there is affirmative evidence of good faith that should outweigh all of the other considerations, including the fact that there was a 3-day court-ordered mediation where the mediator reported to the court at the end of the day that the parties had negotiated in good faith. So there's plenty of affirmative evidence of good faith of an arm's-length transaction. Insolvency only comes in if the court decides that a presumption against good faith should apply. And presumptions are rebuttable. They are rebuttable with affirmative evidence of good faith, which is what we have here. And so it's not the case, as Petitioner's Counsel was saying, that it's a matter of law that the court must find there was bad faith if there was insolvency. It's only a presumption, and it can be rebutted. Plus, the court was right when they said that the only evidence of insolvency here is questionable testimony from Larry Wong saying that NYGFI was probably insolvent. I respectfully submit that there's not enough for petitioners to prove by clear and convincing evidence that there was a lack of fair consideration here and insolvency. One final point I want to make, Your Honors, is that yes, you can affirm on the basis that there was fair consideration, and the DCL 273A claim does not survive on that basis. But the alternative basis is that there was actually never a transfer from the judgment debtor when you look at that $7.6 million payment. If you look at the settlement agreements, they say that the Wongs and the Chus will make that payment. When we went to trial, Alexander Chu testified that Wong agreed to pay $12 million to settle the Texas action. And then later on, when Wong had the exclusive right to negotiate the settlement of the New York action with Alexander Chu agreed to come in and pay a portion of that settlement. He agreed to pay $7 million of it. So nowhere in the evidence is there an indication that there was a transfer from the judgment debtor. I realize that this court previously ruled that there was some kind of indirect transfer from NYGFI, but I respectfully submit that that was a decision based on a pre-discovery record before trial. We've had 4 days of trial now, and it's confirmed that here there simply was no transfer from NYGFI with respect to the settlement payment to the banks. Thank you, Your Honors.
Thank you.
I can honestly say that when I'm standing as the appellant, I've never been happy with what happened below. But the bottom line is that the trial court made some errors. With respect to the issue of timeliness, the truth is that the existence of the real transfer, which was the settlement agreement, was not known until 2012. Even if you accept the proposition that in 2010 they had some kind of a inquiry notice, if you will, the action was timely filed within the 6-month safe harbor. And with all due respect, the Judge Sherwood did not dismiss. It was not a voluntary dismissal. I mean, almost, I think, a large percentage of that case was dismissed by the court, not voluntarily, which means the 6-month safe harbor would have only started, I think, at the end of 2012. So the truth of the matter is that the second action, which we're traveling under now, was actually filed early, if anything, not late. And in any event, the events that we're talking about all arise out of the same transactions and occurrences. It's just it was a different manifestation. This way, they did it with the settlement agreement. With respect to the equivalent value argument, we pointed out repeatedly that there's no equivalent value. New York Guangdong gave up everything and got back a loan, if you will, which probably was uncollectible to begin with. And when they want to question about whether or not there was solvency or not, they say the questionable testimony of Mr. Wong, he was the guy that they gave all the power to. So if he doesn't know, the person you would ask is, was the entity solvent at the time of the settlement? He says probably not. And you look at it, and he also says he can't even identify what the assets were. So it's not questionable testimony, it's dispositive. As to the question of whether or not there was a transfer at all, I mean, Judge Coyne picked this up early on back in this case. These are definitely indirect transfers. All of this came about because the parties had to agree, even the Chews agree, that it was a transfer. Thank you.
Thank you. Thank you, all of you. Real World versus 393 West Broadway.
Good afternoon, Your Honors. May it please the Court, my name is Mark Lane. I represent the Plaintiff Appellant Real World Holdings, LLC. This is an appeal from a 3211 dismissal, so I don't want to spend too much time on the facts. As I'm sure the Court has seen, the facts are kind of lengthy and extensive, spanning a 17-year period and summarized in a complaint that's 121 pages long. It has been a painful experience for my client. They purchased this apartment. It's a 6th-floor apartment in a cooperative in Soho. It's the top floor. It's a penthouse.
We know the facts, but let me just ask you, you're asking for, there's a contract here, right?
There are contracts involved in the case. There's not a contract that gives rise to the claim that's on appeal. There is a contract. The only contracts that are relevant to the case at all are the proprietary lease.
The lease, exactly.
The lease gives right of occupancy and certain rights, but it does not establish ownership.
And this is for a conversion.
It's a conversion claim, yes, Judge.
But is there a conversion claim in real property?
Absolutely.
Can you have a conversion claim for real property?
This court has upheld conversion claims of co-op shares in the past.
But the claim here is not as to the shares. The claim here, as I understand the conversion claim, is as to the use of that property, which is different from the shares, right?
It's a very good question. I believe the Court of Appeals basically addressed that in the Thyroff case a few years ago. The history of conversion obviously is a very long history, and early in the 20th century, it was decided that shares in a corporation can be converted. And it was also decided later.
Here, the issue is not the conversion of the shares, but the
Use.
Is use and possession of the real property.
They are intertwined, and the Court of Appeals has held that. Where you have shares in a corporation that are intertwined with actual property, the conversion of the property can equate to the conversion of the shares. I believe that's the
Do you have any
Thyroff case.
cases that hold that?
I'm sorry?
Do you have any cases that hold that?
Yes, we cited them in our brief, Judge. I believe the Court of Appeals in Thyroff and the case that Thyroff was based on, which was a 1923 case, I believe, the cases have made clear. And this court has upheld cases allowing conversion claims in co-ops based on, there's a case, I forget the name of it, I think it was called Babad, First Department.
But again, that's with regard to the shares, as if it were a
no, and-
stock. But
no,
you're
Your Honor.
saying no, it's
That was-
regard to the use of the property.
It
the use
was,
of the
that case was about a deck on a co-op that the board or the co-op, it's the corporation, took. And this court upheld a conversion claim based on that in a co-op case. So I think there's really no question that there can be conversion in a co-op case by conversion of the underlying property. It amounts to the value of the shares to which that property is appurtenant. And that's how damages are construed. But I don't think anyone has even argued that you can't have conversion in a co-op case by converting the physical property. I think that, to me, that's fairly clear. The elements of conversion, of course, are well settled. The Court of Appeals, quote, when someone intentionally and without authority assumes or exercises control over personal property belonging to someone else, interfering with that person's right of possession. That's Colavito, 2006. There are extensive allegations in this case of wrongful conduct interfering with my client's right of possession. They purchased this apartment in 2008, January 2008, to restore it and live in it. No one has spent a single night.
The issue is rights of possession, not the owner, not the who's holding the physical shares, right?
The issue is interference with the right of possession of the apartment, correct? The shares are appurtenant to that possession.
Counsel, as we sit, as we are here today, you have a claim of breach of contract under the proprietary lease concerning the use of the roof. Is that-
There are claims for breach of the proprietary lease, yes, but they do not relate. I'm sorry?
So you have a breach of contract claim, correct?
We do have breach of contract.
So then, if you have a breach of contract claim, why do you need a conversion claim?
They're different, Judge. There are many different
I
kinds of
understand the difference legally, but why do you need one? You're seeking the same relief. You want to act.
The conversion claim is the only claim in this case that could grant relief to my client based on the complete usurpation of the property that they purchased in 2008 for $8.2 million. The conversion claim is the only claim that has a right to damages for the value of that property. My client has not been able to set foot in that apartment for 7 years. The defendants have completely taken it over. They've admitted that they want to own it. They want my client out of the building. My client are smart business people. They don't put up with shenanigans, with financial misconduct, and they have made that known, and the co-op wants them out. There's a strong motivation. There's hostility that's made clear at every shareholder meeting. They want them out. They want them to leave. They've made that clear, and they've denied all use and access of this apartment for years. In the meantime, my client pays 10% of the building's overhead. My client is the largest residential shareholder in the building and has no use of the apartment whatsoever. Everything in it is destroyed from water, mold, and asbestos contamination. There's no contract remedy that comes even close. My client did not purchase this apartment from the co-op. The proprietary lease establishes certain rights of use and access, but it does not establish ownership. At any rate, this court has held, and the Court of Appeals has held, that conversion claims can exist alongside contract claims and do all the time. This court has held that if the conduct that is alleged interferes with the contractual rights themselves, that can support a conversion claim. This court recently held last year in the, I forget what the name of the case is, I could grab it quickly, but this court held that conversion claims and contract claims can exist in the same case based on the same facts. That's at Last Sportswear from this court last year. So the dismissal of the conversion claim below did not even cite what contract the court found it duplicative of.
Thank you. You have some rebuttal time, so why don't you look for those cases during that time?
Good afternoon, Your Honors. May it please the Court. Jackie Aiello with Smith, Buss, and Jacobs for the defendants' respondents. Counsel spoke a lot about that, he cannot get the full relief that he's seeking because of the breach of contract claims only being...
Can't get the relief through the breach of contract
Through the breach of
claims,
contract
that's
claims.
what he's saying.
There are, with the exception of those that have since been dismissed based on our summary judgment motion, 25 causes of action. It's not just breach of contract that's in there. There are certain conversion claims, there are certain trespass claims. There are already a number of different claims. This claim was raised after we filed our summary judgment motion, after we thought the case was ready for trial. We have been litigating this for 10 years. They moved to amend after I filed summary judgment to add this and another claim. That was the 5th time that the complaint had been amended. So the amendment was permitted, and then we moved to dismiss. And what we raised with the motion court and what we argue in our appeal, of course, is a few things. One is there are no independent tortious acts that are alleged here. The preliminary statement in the 5th amended complaint actually acknowledges that. It says that all of the facts that are within the complaint support both the contract claims and the conversion and other tort claims. That's reiterated in other causes of action. For example, the 6th cause of action, which is a contract claim, talks about the defendant's ulterior motives, the malice, that they tried to extort the plaintiff, that they tried to coerce them to sell, all of what they now claim as the basis for the conversion claim. In addition, I'll say also in the reply brief for the appellant, they bullet point 14 different points of all of these facts that they claim as the basis for the conversion claim that has nothing to do with the breach of contract claims. And although I wouldn't have time to go through all 14, I can point out that each and every single one relates back to either one of the contract claims that's still in the complaint, or a trespass claim, which it would still be duplicative of because the conversion and trespass claims are duplicative of one another. In addition to there being no independent tortious allegations, there's also no independent duty. They say that there is one, but they haven't identified what that may be. And then there was some discussion by counsel about there being different damages. And because there's different damages, that it can't be duplicative. Well, counsel's argument on that basis is because the conversion, the measure of damages for a conversion claim is different than the measure of damages for a breach of contract claim, it's not duplicative. But if that was the case, if we follow that logic, a conversion claim and a breach of contract claim could never be duplicative of one another, which is obviously not the case. What counsel conflates is different damages versus different measure of damages. So a conversion and a breach of contract claim can exist where there are truly different damages. For example, if someone has a home, a roof is being worked on, the roof collapses, they've got property damage, that's one type of damage, personal injury damages, that's a different kind of damage. Here, this is not what plaintiff or appellant is arguing. They're arguing the same damages, just a different valuation. Counsel saying under breach of contract, it would be the value of the apartment at the time of the breach, as opposed to under conversion, with it being a fluctuating value with the apartment, that it would be the highest value between the time of the conversion and the time of trial. It's the same damages. It's the same lack of use of the apartment. It's not personal injury and property damage. So that's what counsel conflates when it comes to this, whether or not he's identified different damages that could support a conversion claim. And finally, I would just point out that, although not discussed by counsel, the 3211 motion that was made, the motion to amend that was made and granted, the motion court did not determine the merits. It didn't look at whether or not there was a legally sufficient claim for conversion. The only thing that the motion court looked at was whether there was prejudice, because that was the big issue, because we had just filed summary judgment. And so it was only on the 3211 motion that followed where the court had actually determined whether or not the conversion claim was duplicative. It was not considered on the motion to amend. Unless there are any other questions, I will.
Thank you.
My time. Thank you.
Thank you. Just to briefly address the conversion of stock point, Thyroff.
I'm not, but the issue the claim you're making in your complaint isn't a conversion of stock, it's a conversion of real property. And that's a different thing, and I'm glad you brought this up, because I don't understand how you can distinguish our court's 2013 decision in BNC Realty Company versus 159 Emmett, where we specifically said that a party may not sustain a claim for conversion of real property.
I'm not familiar with that case, Judge. I'm sorry. I am familiar with the
Okay.
Court of Appeals decision in Thyroff versus Nationwide 2000.
Right, but this one is much more immediately on point and directly on point than, Thyroff is obviously important, but this is 6 years after that and is from this court and says you can't sustain a conversion action for real property. So you can't distinguish that.
This is a conversion action for cooperative shares that are appurtenant to real property.
Thank you.
It's called the merger doctrine. The Court of Appeals
I'm familiar
adopted
with the
it.
doctrine, counsel.
I'm sorry?
I'm familiar with that doctrine.
Okay. Regarding damages, to award the plaintiff damages equal to what they paid for the apartment, even with interest, would be a huge windfall to the defendants. That apartment has gone up very much in value in the 17 years since it was purchased. That's why conversion works. Conversion allows damages in a thing that is subject to fluctuating value, such as stock, for the highest value of the item during the period from the conversion to the date of trial. We're talking tens of millions of dollars in difference. Conversion is the only claim that would give actual damages that would compensate the plaintiff for their losses. Thank you.
Thank you. Thank you both. Gopi versus CVS Albany.
Good afternoon, Your Honors. May it please the Court. My name is Michael Peters with the law firm of Siegel and Uni-Rty, attorneys for the plaintiff appellant Deo-Chan Gopi. This case arises from a slip and fall accident that occurred when the plaintiff slipped and fell on a ice-covered sidewalk abutting the CVS pharmacy located at 1688 Westchester Avenue in the Bronx. The defendants...
Aren't there issues of fact here with regard to the sprinkler, the ice, whether it was water or ice, or whether the sprinkler had been turned off, or who turned it off? Aren't there myriad issues here that have to be resolved?
Well, I don't agree with that premise, Your Honor, because the lower court basically essentially found two things that it determined were issues of fact. Number one, what caused Mr. Gopi to fall in the first place? And number two, what was the source of that thing that caused him to fall? The plaintiff testified no less
Sounds like those are a couple of issues right there.
Right, but Your Honor, the plaintiff testified no less than 11 times during his deposition that he slipped and fell on ice. There is absolutely no evidence from anyone to dispute that.
His testimony wasn't particularly clear. He said water, ice, several times.
But he was clear on that point, Your Honor. And in addition to that, both of his sons who came to the scene of the accident after the accident, both stated that they saw ice on the sidewalk. And in fact, the certified ambulance report...
There may have been ice in some spots. It's about which spot he fell on.
Right, and the certified ambulance report, Your Honor, says that he was found sitting on ice. That was a quote from the EMS personnel. So
I don't doubt that either.
Okay, but my point...
The question is, what did he fall on? What did he indicate that he fell on? The pictures show water and ice Even if he was sitting on ice, there was also water there, and it's unclear where that came from.
And Your Honor, I would disagree with the second part of that as well, because we have ruled out all other possible sources of the ice in this situation. We submitted the report of an expert meteorologist who opined that there were no other, that there should not have been any natural rainfall or snowfall that was remaining in that area at the time that the accident occurred, based on certified meteorological data. And you know, we have a video and an affidavit.
But the video was taken in September of 2020, like when the sprinklers were working. This is
Correct.
December of 2019 when the accident happened, and there was an invoice in the record. By the way, CVS is not responsible for the sprinklers, it's really the landlord, but okay. But that suggests that the sprinkler system was turned off. So it's an issue.
What's very important, Your Honor, about that invoice that you saw is that it does not pertain to the subject property. If you look at that page of the record, it pertains to the owner of the company that owns that Rohav. It pertains to his personal house. It does not pertain to the subject premises. I don't know why the defendants even disclosed it, but it's very clear from its face that it does not pertain to the subject property at 1688 Westchester Avenue. And so there's no evidence in the record that they winterized the system during the fall prior to the happening of the accident. And that video, which was taken, again, I will admit, several months later, was submitted solely for the purpose of establishing that when that sprinkler system does operate, the sidewalk becomes wet due to the fact that they overshoot the planting beds and that water is sprayed onto that sidewalk. Now, I wish I had a video from that winter, but I don't have that. What I do have is I have photographs taken a month after the accident showing that this was a recurring condition, that the ice continued to form on that sidewalk in the same fashion that it did on the date of the accident, again, due to the operation of the sprinkler system at the premises. And there's frankly been no other explanation offered by the defendants for how ice came to form in that fashion on that sidewalk other than the operation of their sprinkler system at the location.
And that gives them notice?
Well,
is that the notice?
It's not a notice issue, Your Honor. It's a cause and create condition. They chose to operate a irrigation system at their property in the winter months when it was below the freezing point. They caused and created the ice to be there by their use of their automatic sprinkler system. And so no notice is required where you cause and create.
Thank you.
Thank you.
May it please the court, Your Honors. Andrew Kolowitz of Furman, Kornfeld, and Brennan for CVS Albany, LLC. I have to take exception with what counsel said in that his client's testimony was unequivocal with respect to what he fell on. That's just not the case. I could cite to the record where he says time and again, yes, I fell on water and I fell on ice. I don't know, I don't remember. Sir, do you recall how you fell? I fell on the water where I fell on the ice by walking on
So
water.
you believe there are issues of fact?
Issues of fact all over the place. And I'll tell you this, his sons who came back to the scene of the crime, so to speak, after the fact, a month later, they're sitting, snapping photographs. Nobody's seen these sprinklers on around the time of the fall. They live a couple blocks away, so they thought to come back, take photographs, hang out there. But the only one who's posited the assertion that the sprinklers were on at the time is counsel. There's no proof in this record, any proof in this record that at the time of the fall in December that the sprinklers were activated. Again, as Your Honor pointed out, an investigator comes upon the scene 10 months later and observes these sprinklers on. It was a different season, different time of year. They're playing baseball still. It's still the tail end of the summer, right? The sprinklers are on.
I think you indicated no issues of fact. I don't know if there's another point you want to make.
No, and I will just reiterate the point that CVS should not be lumped into the same category of defendants as the owner of the building, given the different degrees of responsibility and tasks for maintenance of the sprinklers under the lease agreement. But the court gets it. There are issues of fact here.
Thank you.
Thank you.
Good afternoon, Your Honors. Todd Harris from McAngus, Goodlock, and Corey for the respondent, 1688 Rohav Realty. Your Honors, we submit there are questions of fact which do not warrant summary judgment. I do not want to rehash my colleagues' arguments. We take the same position, and unless the court has any questions for me, I'm happy to defer to the arguments that were raised and our papers.
Thank you very much.
Thank you very much, Your Honors.
If I just may briefly, Your Honor, counsel stated that the plaintiff's testimony was all over the place, and I have to very strongly disagree with that. Yes, he did use the word water, and he used the word ice, and I agree with that. I don't dispute that he used the word water. But again, as this court, I think, has already indicated, the photographs show that it's a mix of water and ice. We're not talking about solely ice everywhere. And I think we all know that when you have a mix of water and ice, that can be a slippery situation. And that is caused by their sprinkler system. So whether it's water, whether it's ice, whether it's a mix of water and ice, the plaintiff was always clear that that's what caused him to fall. He never testified that he tripped over some defect, that he lost his balance, that someone pushed him. It was never anything like that. It was very clear at all points in his deposition that it was ice or some mixture of water and ice, which was slippery, and that's the cause of the fall. There's no evidence to dispute that, and so the lower court's determination that there was a question of fact about that, we submit was incorrect. And that's all I have.
Thank you.
Thank you.
Thank you all. Aponte versus Town of Islip.
Good afternoon, Your Honors. May it please the court. My name is John Scola on behalf of Appellant Nicholas Aponte. This is a appeal based on a granted motion to dismiss, which we believe is granted in error. It's kind of a unique situation here. Our client brought claims for disability association under state human rights law and also for caretaker discrimination. We allege that both of those are now viable claims under, well, they might have always been, but they're certainly now viable claims under state human rights law due to the association claim, which is in city human rights law. Yes.
I have trouble with what your association claim is. It seems to me that from the record I've seen, it appears the reason that he wasn't given the job was because of his acknowledgement that his wife occasionally smoked marijuana. And that didn't have to do with, I mean, she could take care of somebody with or without using the marijuana that her patient used. I don't see why the allegation that he was denied a job because of his wife's use of marijuana necessarily implicates disability discrimination.
Okay, so at this point, it's unclear exactly what the real reason for the not giving him the job was. It's pled as if it's related to his mother-in-law's disability and also his wife's use of marijuana. Now, we don't know which way or which one. We might get into the case, and it might just be because of his wife, and then in theory, we could lose the case. But the way it's pled, which is the court has to accept as true, is that he was fired or not given the job based on his association with his mother-in-law. He doesn't use marijuana. He passed the drug test a week before the interview. There's no history of drug use or drug dealing. He is associated with his mother-in-law who uses marijuana. Whether his wife also uses the marijuana is really, I don't think it's related to our claims here. It's pled as if it's a disability association claim based on his association with his mother-in-law.
So that's with regard to the Kane statements that were made?
Sure.
Okay. And would you have an issue with the notice of claim here?
So we're not suing the town of Islip. They didn't make the defamatory statement. Craig Kane did.
He made the statement as an employee of the town of Islip. The phone rang, he picked it up, he said, yes, I'm the so-and-so, and here's the issue with regard to this guy. So they have to step in and represent him. They are a party here. They have to represent their employee.
Well, I'm not suing him in his employee capacity. If that's what the court is going, the position the court takes, I'm probably drawing dead here, to be honest with you. But it seems like the way that it's pled is where he is sued in his individual capacity. He was acting outside the scope of his employment as per the affidavit submitted by the respondents. It doesn't say that he supervised my client or even gives recommendations in that affidavit, but he gave a misleading statement to the NYPD, which cost my client the job. He called him a drug dealer when he's not. He said that he used drugs when he didn't. He said that he was.
I understand what you're saying, but I don't understand how he was not acting as an employee in the scope of his employment when he made those statements about the person who had been interviewed and who he may not have believed it, he may have believed it, whatever it was, he made those statements in respect to his position.
So I'm not sure the answer to that, Your Honor. If that's the case, then he could never be sued in his individual capacity for statements that he made at work. And that we're suing him individually. And under city human rights law, you can sue people individually for their actions. It's the same thing here.
But he would have had to have been doing his work outside the scope of his employment, and he was clearly doing it within the scope of, whether you agree with his statements or not.
Yeah.
He was an employee of the town of Islip. He was the NYPD interviewer, investigating your client for the job, called him in the context of getting a recommendation or a referral based on the last place of employment. It wasn't someone off the street.
Right.
You agree with that?
I agree that he's an employee of town of Islip, but I don't agree with that he was the one that was supposed to do that recommendation or reference. It's not in his scope of employment as submitted by the defendants in the case. If it said, I respond to all HR calls and then I give recommendations on employment based on my position as a supervisor for the town of Islip, well then I would agree with you. But he was acting outside the scope of employment as per those employment duties set forth by the defendants. And that's probably why he told a lie when he called, and my client didn't get the job. It's defamatory. So under this theory, he could say anything he wanted. The town of Islip's the only one to be held liable. We would think that the individual should be culpable for his own actions. Thank you.
Good afternoon. William Wexler. I represent the town of Islip, defendant respondents. The court below was correct in dismissing the claim. First, the claims are barred for the failure to file a notice of claim. New York Town Law 67-2 is very clear. Any claim made against the town shall be made in compliance with general municipal law. And this theory applies to cases filed under New York State human rights law. The court below, and in our brief, we cited two appellate division cases as the court, a fourth department case, and two United States District Court cases, Southern District. In fact, the fourth department case, Arnold, in 2023, said notice of claim is required for an action alleging violations of human rights law. In fact, the case went on to specifically state that the case relied on by Appellant, the Margaram case, New York Court of Appeals, did not alter the case. A notice of a claim applies to municipalities afforded notice pursuant to New York Town Law. Had the plaintiff even filed a notice of claim, it's barred by the statute of limitations. Year and 90 days when you sue a town, which equates to 454 days. You add another 228 days due to COVID, the executive law. That is 682 days for a complaint to be filed. In this case, the plaintiff waited 1,137 days, missing it by 455 days. Additionally, the complaint fails to state a cause of action pursuant to Human Rights Law, Section 296(1). The plaintiff was not an associational caregiver, and the appellant's reliance on the Chiara case, Second Department, and the Macchio case are misplaced. Both of those cases where plaintiffs were associated with individuals who were under the class protected by Title VII. In this case, and it's not the wife, it was the girlfriend. It's the employee who, I guess, associated with the girlfriend who was a caregiver to her mother. That does not apply. And the court below elected not to expand the law and specifically recognized that there was a bill pending in Albany to amend that law, but it wasn't the law at the time, and it's still not the law. And then going to Defendant Kane, I think the court was right on. General Municipal Law 50E requires a notice of claim when a municipality has a statutory obligation to defend. In this case, the defendant Kane being sued individually, Islip Town Code 24-3 requires that defense and indemnification of the employee acting within the scope of his duties. And it's clear, just from the complaint, the defendant Kane worked for the town. He was directed by a supervisor to respond to the phone call to an investigator. He was talking about town business, about a former town employee in town hall on a town phone. That's certainly within the scope of his duties. Thank you.
Thank you.
Thank you, Your Honors, and may it please the Court. Cleland Welton for the state. Supreme Court correctly granted the state's motion to dismiss for two reasons. First, the complaint does not allege facts supporting showing that the state engaged in any form of hiring discrimination. And second, the state human rights law does not support the plaintiff's legal theory. On the first point, Justice Gesmer, you're totally correct. The complaint does not allege any concrete facts which would support an inference that the state decided not to hire the plaintiff because of his mother-in-law's disability. The complaint expressly and affirmatively alleges that the state decided not to hire him as a state trooper based on a text message in which he had condoned his wife's illicit drug use. The Supreme Court correctly determined that's not illegal discrimination. It's the decision not to hire a law enforcement officer who had a record of acquiescing in illegal activity. The court can and should affirm on that basis alone. The plaintiff has not even argued the contrary in his briefs. On the second point, we would agree with the city and the town that the legislature has not extended the state human rights law to a person like the plaintiff who does not himself suffer from any disability. The state HRL provides it's unlawful for an employer because of an individual's disability to refuse to hire such individual. The plaintiff here is not an individual with a disability, so he's not covered under the statute.
Does he have caregiver status?
Does he have caregiver status?
For his mother-in-law?
I'm not sure. I think he alleges at least that much in the complaint, but he doesn't. For purposes of the state human rights law, that's not really relevant because there's no protection under the statute as it's currently written.
For a caregiver.
For a caregiver. The legislature is considering whether to add that, but they haven't done so yet. They haven't added associational discrimination claims either, and without either of those, he has no claim under the plain language of the statute as it's currently written. Whether to act another new cause of action is a matter for the legislature, not for the courts. If there are no further questions, we would just ask the court to affirm.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Diana Lawless on behalf of the City of New York. So we agree with all defendants were united that the state human rights law doesn't have causes of action for caregiver status and an association with a disabled person. But the city human rights law does. And when it comes to the allegations against the city, this complaint does not allege facts that would support those two claims against the city. There's no facts that the city failed to hire the plaintiff as a police officer under circumstances giving rise to an inference of discrimination regarding these statuses. There are no allegations that the city even knew about these protected characteristics. The only allegations in the complaint is that the city didn't hire the plaintiff after an employee of the town, who's his former employer, told a city investigator that the town had terminated his employment for drug use. Nothing about the statuses. He also alleges that the city didn't inquire into the actual events. So if he didn't inquire into the actual events, and his story is that the actual events revealed these statuses, there can't be liability for the city. There's no motivating allegations, and I think that the motion for leave to amend, which plaintiff's counsel hasn't mentioned yet, it just made it worse because it adds allegations that it was told that he was not hired after they told him that told the city that he sold drugs and was a criminal, and attributed the city's decision not to hire him exclusively to an automatic rejection for marijuana use. That has nothing to do with any of the statuses. So for this reason, we ask that this court affirm dismissal against the city. Thank you.
Thank you.
I'll say that the case in Machia, it was a race claim, but he liked black things. He liked black music and black culture, and they made fun of him for it. My client's association with his mother-in-law is much more obvious than the one in Machia. I will say that the standard here is notice pleadings. We pled that my client was discriminated against based on his association with his disabled mother-in-law. The court has to take that as true. All these other arguments based on evidence and documents and all this stuff, it is not proper at this stage. My client pled caretaker discrimination and association disability discrimination. There's no association claim for race in the statute. That is allowed in the Second Department. There's no association claim for religion in the New York State human rights law. That's allowed in the Second Department. There's an association claim under the ADA and the New York State human rights law. These claims are viable. The court should reverse. Thank you.
Thank you. Thank you all.
Good point. People versus Dilla.
Thank you, Your Honor.
You may proceed.
May it please the court, Alexandra Mitter for appellant Paul Dilla. I'm here today asking for a very limited scope of relief. While federal prosecutors in the Southern District of New York believe Mr. Dilla is innocent, I believe Mr. Dilla is innocent. I'm not asking this court to exonerate him. I'm not realistically even asking this court to vacate his conviction, though I think the latter would be perfectly appropriate given what happened below. I'm simply asking this court to remand for the hearing to which Mr. Dilla is clearly entitled.
I understand what you're asking for. I have a question that may not be immediately relevant, but just something I don't understand. The allegations in the papers are that your client met Mr. Anoa in 1996, but he didn't make any motion based on what he learned from Mr. Anoa until 2022, 26 years later. Can you tell me something about that?
I can a little bit, and I believe it's mentioned in the reply below. There's rules about prisoners, incarcerated people communicating with each other, and so a past chance encounter with someone in prison, once that person is transferred to another facility, there's no way to get in contact with that person again. And then prior to my office's involvement that ultimately resulted in the filing of this 440 motion, there was significant interaction with the Bronx CIU's office by prior counsel. So there's still a long time between Mr. Dilla first meeting Simon Anoa and when the CIU got involved in, I believe, 2018. But I think that's explained both by the nature of incarcerated communications and also based on one person telling another person that this thing happened. I mean, of course, Paul Dilla wants to believe that that's true, but until we get the proof, it's a very different case to bring as a 440 motion. We now have the proof, right? SDNY did the right thing here.
Speaking of proof.
Yes.
So given that Mr. Anoa died some 6 or 7 years ago, how would, if we were to agree with you and grant a hearing on actual innocence, how would it proceed?
So I think there's a number of different ways it could proceed, Your Honor. We provided sort of a non-exclusive list of people we could call. We could call the alibi witnesses for Mr. Dilla that testified at the first trial. We could call Mr. Dilla himself. We could call the individuals who Simon and Noah identified as the perpetrators in the actual crime. I mean, there's a lot of places we could go here at an actual innocence hearing.
So would it be a fair statement that you're really focused on this and not really pushing the Brady issue?
I think a hearing is warranted on both of these claims, Your Honor, because I think they're really quite intertwined. I mean, I think we have a real threshold problem on the actual innocence claim in that the court applied the post-hearing standard to our pre-hearing claim. But on the Brady side of things, the court also made sort of a fundamental error in...
But the Brady claim also relies on the district attorney's office having some of this information before your client's second conviction or eventual conviction. And I didn't see anything in the record that showed that Mr. Anoa had claimed responsibility for Mr. Lopez's shooting before 1998. So how would that get you a Brady claim?
So Mr. Anoa absolutely did claim responsibility for the for the Lopez shooting and the Maldonado shooting, which was introduced against Mr. Dilla at that trial prior to Mr. Davila's retrial. In fact,
When? I didn't see that anywhere.
so there are a number of instances. On November 5th of 1993, and this is in proffer notes that were attached as Exhibit F to the motion below, bait stamped beginning on SE 37. We have a variety of notes related to that November 5th proffer. He's saying he hired hitmen to do this shooting of Mr. Lopez. That's what's happening in these proffer sessions, which are all happening in November of 1993. And that's a totally different theory than the theory that the prosecution put forward against Mr. Davila at trial. At trial against Mr. Davila, it was like Simon and Noah didn't exist. But Simon and Noah is telling federal prosecutors, and in fact pleading guilty in federal court, to being involved in both of the shootings that are either Mr. Davila is being accused of or being used against him. And the theory that Mr. Noah is explaining to federal prosecutors at this very same time is that Freddie Concepcion had ordered the murder of his brother the month before. And he began this sort of large-scale plan of retaliation that involved shooting Amador Lopez after he'd left the Concepcion's residence, that involved shooting into the Concepcion's residence, which killed Magdalia Maldonado, and involved a series of arson attempts, all in the months after Wilfredo Concepcion killed his brother. That is entirely divorced from the prosecutor's sort of like contorted theory at trial that Mr. Davila did this shooting to silence witnesses to a murder that had happened 2 years earlier. So it's not only a different theory, I would posit it's a better theory. But under either version, Court of Appeals law makes it really clear that the difference in theory, and I'm talking here about 2019 cases Ronghi, 2019 case Ouellette, that where it directly contradicts the people's theory of the case, that's material under Brady. What we have here is far stronger than what happened in Ronghi, for example, where it was one witness saying that 2 people had done the shooting when the prosecutor's theory was that only one person had done the shooting. It wasn't that the defendant wasn't either of those 2 people, it was just an important difference in the theory of the case. And here we have so much more than that. We have a federal prosecutor, a federal cooperator telling the feds, who are in turn relaying information to their Bronx counterparts like they're supposed to, that the way the prosecutors are telling the jury this case happened is not how it happened. And for the trial court below to have denied the motion on the possession prong, sort of the most fact-intensive portion of the Brady analysis, when we have a lot of insight, given SDNY's openness, but not certainly the full picture, because the full picture is behind lock and key on this side of the aisle, to say that we didn't put forward allegations tending to substantiate the essential facts, which would be 440-34B, that's simply not a fair reading of what tending to substantiate means. And I think that the particular problem here is that essentially with one hand tied behind my back, the court said I hadn't done enough, when on the other side, the prosecutor put forth no facts. They could have looked through their files. I can't look through their files. They can look through their files. They could have put forward affidavits from the relevant prosecutors. They didn't do that. Thank you.
Good afternoon. 88 Nicole Nichols for the Office of Darcel D. Clark. May it please the court. Despite what defendant says, quite frankly, this case is built on suppositions, prepositions, speculation, none of which warrants a hearing.
Counsel,
certainly,
why doesn't the fact that Mr. Anoa admitted to some agent in 1998 to the murder of Mr. Lopez justify an innocence hearing?
It does not, because A, Mr. Anoa is no longer here. There is nobody that we can call to verify what he is saying. There's no details about this statement. And when you compare that statement to his earlier statements, his statements in 1993, at the time when he is seeking cooperation with the federal government over the very serious charges he was facing, those statements implicated Mr. Davila in this in the shooting of Lopez. At that point, he certainly says he arranged for hitmen to get there, but he said Mr. Davila was one of the hitmen who were hired to commit that shooting. He placed Mr. Davila at the shooting, the subsequent shooting that led to Maldonado's death. So
Ask you,
when
when is he scheduled to get out? When would he be released? When is defendant scheduled to be released? Or
not
eligible?
anytime soon. His sentences were run consecutive, and I believe he had a 25-year sentence. He also
For
had
the
a
murder
15.
of Edward Concepcion, correct?
Exactly, and that murder is not before this court. And I would say partly everything Inoue said in his statements corroborated the fact that the defendant was also the murder of Edward Concepcion. So, Your Honor, given that there was no factual issue here, the very evidence that the defense submitted of the proffer notes shows that the people were not in actual or constructive possession of that information at the time of defendant's prosecution. The conversations between the prosecution, the federal prosecutors and the state prosecutors, there was no conversation during
There's some
the
indication in the record that there were 12 boxes of files in the DA's office, but I didn't see anything satisfactory showing that anybody had actually gone through all of those.
Your
Has that
Honor,
ever happened?
that allegation is the definition of the type of speculation that basically forms the foundation of this case.
Well,
May I, Your Honor?
I'm sorry. So let's rule out the Brady issue. That's why I said earlier, there are two issues here. There's one with Brady, which they have to establish that the district attorney's office prior to at the time of the trial and conviction had information that should have been turned over. That's the issue there.
Right.
Or putting that aside, there's a separate issue of actual innocence.
Right.
Which is, and again, you don't need a high bar there. You just need to be able to give someone due process and have the hearing to determine, is there anything there?
That's correct.
Fair?
That's fair.
So what's your thoughts on that? And did the court below not quite deal with it in the appropriate way?
Violence, if I could just finish this one, I would just note, Your Honor, that just because of the allegation is that somehow I did not review files and filed my response, that the very extensive response that the people submitted made clear that we reviewed all the files in our possession and made that apparent to the court. Our response was basically a reflection of the fact that we reviewed every file that we could, and there was nothing there beyond the papers that were attached as our exhibits. As to the actual innocence, Your Honor, the court, I believe, looked first as to whether there was anything other than these two, this 1998 simple statement, Pauly didn't do it, which is made after defendant admits that defendant and Mr. Inoue had met and had this conversation, and Inoue had given him this information, and made in light of the 1993 statement that the court said no hearing was required, right? Because there's nothing that we could do to bring forth as to that issue. Inoue is not available to testify, and there was no other witnesses that really could call to verify his statement.
Yeah, but if someone repeats hearsay that he said, for example, I'll use the acronym, OSA, I think it is, Park, where he actually heard from Mr. Inoue saying that he was responsible for the attempted murder of Lopez and the murder of Maldonado, just by way of example.
But
wouldn't a hearing allow Mr. Park or anyone else that may have been involved in that process? And that would be an exception to the hearsay rule because it would be an admission against penal interest.
No, Your Honor. First of all, the initial statements, right, of Mr. Inoue in 1993, those statements does not say defendant is innocent. Only the 1998 statement says he does not do it. The 1993 statements are certainly not against his penal. Those statements, in our argument, inculpates defendant in those crimes. Those say Pauly was the hitman that was, together with the other four, were hired to commit the murder. And the second one, that Pauly was also there when they shot Maldonado. So the only statement that Paulie didn't do it is said in 1998. And that statement was made not under oath, not in any, certainly not part of the proffer statement. It was somehow made to, AUSA Park with no explanation, nothing else given. So I think the court says that's not enough. That's an equivocal, and that's not actual, that doesn't get you to actual innocence door. I'm sorry, ask that you affirm.
Here's your pen. You lost your pen.
You may proceed.
On the actual innocence claim, it's not as if...
Counsel, so the judge didn't grant the hearing because he didn't know how you were going to prove your side of the hearing?
No, I think that's absolutely not why the court didn't grant the hearing. The court didn't grant the hearing because he applied the wrong standard of proof. There's just no question that that's what happened here. And Your Honor's absolutely correct. We can rely on hearsay, and there's simply no way you can contort yourself to find that acknowledging your role in a hired murder is not against your penal interest. And there's also no question that hearsay is allowed in actual innocence claims. And so I think we're on very solid ground that we should get the actual innocence hearing. And then on the question of proof of possession with respect to Brady, I want to be really, really clear. In the SDNY documents that we were given access to, there are 8 or 9 documented interactions between the federal prosecutors and the Bronx prosecutors and or the NYPD. On November 10th, just days after Anoa first comes clean and tells AUSA Park that in fact he was involved in these 2 shootings, AUSA Park does the right thing and calls the then chief of homicide to let her know. All we have in response to that, all we have to controvert that is ADA number 1 telling ADA number 2 that ADA number 3 doesn't remember whether there was a conversation.
Counsel, could you conclude?
Yes, and so for all of those reasons, I'd like to ask that ADA questions at a hearing, and that's perfectly appropriate and in fact mandated under the CPL. Thank you.
Thank you. Oh, I didn't call the case yet.
Sire Spirits versus Beams Centori.
Good afternoon, Your Honors. Paul Fishman from Arnold and Porter on behalf of Appellant Michael Caruso and the other Caruso defendants. In November of 2023, we filed amended counterclaims. That set out 2 things very clearly. One is that on February 13th, 2020, coincidentally 5 years ago today, Curtis Jackson had someone place a hidden voice recorder in a room with no one's consent.
So we know the facts. We know that that happened. Yes.
But my point is, Your Honor, that fact was pled completely adequately in the amended counterclaims, as were the additional uses and disclosures of the recording after that date.
But in your
So you're solely
amended
focused with
counterclaims,
the 4th and 5th counterclaims?
The fourth and fifth counts.
Right, not the 2nd and 3rd.
The 2nd and 3rd were based on the original recording,
Right.
and the 4th and 5th were based on the use of disclosures. Nobody actually argued in front of the Supreme Court below that the complaint was inadequately pled, nor was the decision to dismiss those counts based on that holding applying the CPLR. Instead, the Sire Spirits counterclaim defendants raised 3 different defenses, effectively, to those claims. One was the statute of limitations, one was this doctrine of applied consent, and one is unclean hands.
so under the, let's talk about them then. Okay, so under the time barred, are these time barred? I mean, this was disclosed and it was 2 years.
So let me deal with counts 4 and 5 that Justice Schulman just raised first. Those allegations relate to activities by Sire Spirits in its amended complaint in this case, which was filed in May of 2023, not even 2 years ago now, and the use at our client's deposition in March of 2024. There's no argument, I suggest to this court, no argument that those uses and disclosures, which are distinct and separate violations of the federal and New Jersey wiretap statutes, are time barred.
But it was July 2021 was the time that it was.
So if I may, we received the recording for the first time in July of 2021. I'll get back in a second to whether that gave us a reasonable opportunity to discover that the recording was illegal.
Because there's no counterclaim until 2024.
There's a counterclaim in 2023, but the federal and New Jersey state wiretap statutes make it a separate and distinct violation, irrespective of that, because we knew it's still it is within 2 years since those events happened. So even if the recording itself is time barred, counts 2 and 3, counts 4 and 5 are clearly not, because they happened well within the 2-year statute of limitations. That's first. Second, federal law and the New Jersey statutes say exactly the same thing. You have to have, it's whether you have a reasonable opportunity to discover the violation. And in that regard, the complaint, our counterclaims also very clearly plead the many ways in which we were denied that reasonable opportunity. The deception, the repeated misleading by Sire Spirits and its counsel during the arbitration and afterwards. And I'll point the court to one example, and I respectfully request that you take a very careful look at this after the argument. If you look at record pages 1002 and 1003, during the arbitration, Mr. Breslin, who was representing Mitchell Green, we were not a party to that arbitration, inquired of Mr. Sava, the general counsel of Sire Spirits, about who had actually consented to the recording. And Sire relies on that exchange here for their argument that somehow Mr. Sava had implicitly consented. But in the middle of that colloquy between Mr. Breslin and Mr. Sava, Mr. Breslin says, well, basically, who authorized this? Who consented? And Sava said, I didn't know about it, and I didn't consent. He was asked, what about Mr. Jupin, the FBI agent? And he said, I don't know. That was a lie. He knew that Mr. Jupin had not consented at that point because Mr. Sava had gotten the original recording from Mr. Jackson a year earlier. That's first. Second, if you look at page 1003 in the transcript, what you will see is that counsel for Sire Spirits, because the arbitrator was sort of interested in this question, and the arbitrator said, hold on a minute, who was in the meeting? And a fellow named Mr. David, Donald David, who was then representing Sire Spirits, said, if I could, again, I'm going to object on the entire line of questioning. New Jersey is a one-party state in terms of this, and therefore it makes no difference who recorded the meeting. Why is that important? Because Mr. David was telling the arbitrator that someone had consented. Now, he may not have known that no one consented, but Mr. Sava, who was sitting there, knew that no one had consented because he knew that the person who had put the wiretap there, who had put the bug in the room, was his client, Curtis Jackson. To answer your question, Judge, to circle back.
Where is it that he knew at that time that it was his? I know that Mr. Jackson put it there, but where is it that he knew that Mr. Jackson had it there at the time of that conversation?
In our counterclaims, we allege, and Mr. Jackson admitted at his deposition, that when he picked up the recording that night, he gave it to Mr. Sava. And Mr. Sava knew that Mr. Jupin didn't consent, Mr. Green certainly didn't consent, and Mr. Sava didn't consent. So they knew. Now, the question is...
But he didn't know at the time it happened. You're saying when he picked up the recording later.
The next day in 2020. So as of the arbitration in 2021, the question you asked a minute ago, or a few minutes ago, Judge, was whether we were unreasonable, whether we had a reasonable opportunity to inquire. And the question is, having received the tape from the United States Attorney's Office, who wouldn't have given us a tape, we believed, that was illegally recorded without telling us that, and having read the transcript...
I don't know what they would have said, but provided it to you.
But they're not supposed to give out illegally. They didn't make it. But in any event, all we knew in July of 2021 is we had a tape, and that Sire had been using that tape in the arbitration, and that they had essentially told the arbitrator
But you have a tape. You're saying the U.S. attorney didn't, don't you ask questions at that point? I mean, you could have asked them anything you wanted, couldn't you?
No, they
said, no, we're not answering any of your questions?
There was no dialogue, it was just provided to us. But
They said that, we're not answering any of your
they will not tell us about the conversations they had with Sire Spirits. We've been trying to find out in discovery from Sire whether they did that, whether they have it. But if I may, Justice, it's still a question of fact that was not susceptible to a decision at a motion to dismiss stage. And let me make one other point, if I may. Even if we were out of time to sue in counts 2 and 3, which I don't think we were, we still have counts 4 and 5. And beyond that, you can't use the tape ever again because it is still an illegal recording. There's no statute of limitations under Section 2515 of the federal statute that says you can't use an illegal recording in any proceeding in state or federal court. And
so you're referring to claims not within, let's say for a moment then, not within those 2 years, but you're saying for every time after those 2 years.
Assuming that this court were to find that we had a reasonable opportunity to inquire as of July 21, then the recording claim would have expired in July of 2023. But every use, if they use it today or tomorrow, and the reason that's important, Justice.
And which of those are you aware of?
We're aware of the ones that are all pled in the amended counterclaims. But to be clear, we have been seeking discovery from the Sire defendants to find out what other uses they've made of the recording, who else they've played it for, who else they've told about, and what use they have made of it in this litigation.
So you would be referring to then, for example, the recording and transcript on the public docket in February 1st, 2024, in connection with the dismissal of the Caruso parties, that one?
So anytime the tape...
I only asked that question because then that particular those documents were sealed on February 8th. So I'm wondering, in those 7 days.
Well, we didn't file. We immediately tried to get it sealed, and which is the same thing we did. And it was one of the reasons we didn't provide it to this court when we filed our appeal. We were concerned about that, and it's because no one actually referred to the rest of the recording at all during the arguments in front of Justice Crane. We didn't think it was part of the record appropriately anyway. But yes, the federal statute recognizes that every time an illegally recorded conversation is used, played, disclosed, or even used in evidence, it's another violation.
Yes, beyond that period, yes.
It would be beyond July. It would be beyond July at any point, Judge. No, it's not. That's not barred by the statute. So if they use it today, if they file another document with it tomorrow, right? Yes, correct.
I was just wondering about your own client's use. Was there any use from your own clients?
There were 2 occasions during that are in the record during which I asked questions of witnesses. But the law is clear. If I'm trying to explore our defense to the use of the recording, I have to be able to ask those questions. That's one issue. The second is, and we may get to that down the road, but neither of those, Justice, are a reason to grant the motion to dismiss, which I think is really important. There is no doctrine of unclean hands under the federal and New Jersey state wiretap statute. As this court knows better than I do, it's a rule of equity, not a rule of law. This is a statute that doesn't provide for that. And even if you are right, even if the Sire parties are right, that there is something that we might have done that would have a balance of the equities, honestly, Judge, bring it on. I would be happy to have that balance of the equities, and not only that, but even if that's appropriate, it's not appropriate on a motion to dismiss. If we're going to talk about whether we used it inappropriately and whether there's a remedy for that, as I said to Justice Crane, I would be perfectly fine getting rid of all of that because we are right that the recording itself should never have been made, should never have been used at all. The same thing, I know I'm out of time, but with the court's indulgence, the same thing is true of the implied consent. There's no doctrine of implied consent here. The statute says prior consent, and that's just not enough in this context.
Thank you.
Thank you.
May it please the court, I'm Judith Gish, and I'm here with Molly Hendenberry, and we represent the plaintiff respondents in this case. I think if we start with the premise here that understanding this is a motion to dismiss, we also understand that if there are defenses that conclusively and as a matter of law apply to the claims that are made, then the claims are properly dismissed. And that's what we submit is going on here. Truthfully, the different defenses, and there are a myriad of them, apply differently to different claims here. Certainly, the recording claims, there's a claim regarding statute of limitations. And I think something that was repeated to Justice Crane, and I think Mr. Fishman actually alluded to it here, that his client is allowed to use the tape and transcript for whatever reason he wants, but then if he asserts a claim against my client that pertain to the legitimacy of that taping and that record and that transcription, that we are not allowed to use it in a defensive posture. I think if you start to look at the ways in which we used the tape, you'll see that we were very respectful of not necessarily making it a public document, but using it in a defensive way that would otherwise be a defense, really in the first instance, to the Illinois wiretapping claim, which was in existence when most of the so-called offending uses were in play. So I think that under that rubric, you can understand why Judge Crane said, gee, this was in bad faith and unreasonable. And we do concede there's no such thing as an equitable defense of unclean hands in an action for law, but there is a defense of waiver. And when Justice Crane rewrote or wrote her decision more formally after she stated on the record what she believed, what she did is she talked about waiver. And I think there's a lot of waiver here that is a complete defense to many of the offenses. I want to look at the some of the defenses, and I have to say, in the brief we talk about many more, and I think they're just as good, but I think that these are ones that I would call really graspable, and that's why I'm dwelling on these, but they're not, by no means are they the only ones. So let's look at the statute of limitations, right? So here's what happens. We know that there's a—
Can I ask you, I'm just going to ask if you would look at, for example, the failure to sufficiently allege intent or interception
You mean
of the
the
device.
February 10th?
Let me see. Whether counterclaims should be dismissed, for example, not with regard to the time bar, but with regard to the failure to sufficiently allege intent or interception of using the device. Can you focus on that for a minute?
And I'm sorry, I'm just going to ask you to clarify for me when you say 10, you're talking about paragraph 10?
Intent. I'm sorry.
Oh, intent.
Yes, I'm sorry. I said
I'm sorry.
a failure to sufficiently
It's been a long
allege
afternoon for everybody, right?
intent.
Okay. So I think what's really happened here is that if you look at the particular claims that are made, and I'm talking about the use ones, not the ones that are barred by the statute of limitations, because I do admit that, in fact, every time we use it, there's a potential claim and a new statute of limitations runs. However, there are defenses for these. So they really kind of fall into two groups. One bucket is the claim that we improperly used the tape to frame our complaint and our amended complaint, and I'm going to get to that later. But I think there are a bunch of claims that are made that in the context of this litigation, we brought up the tape and we brought up the transcript, and I think that's true, but we have to look at the context in which it was brought up. So for instance, on December 18th, they allege we produced the recording and transcript to all the parties in this action. Why did we do that? We got a discovery request from Mr. Caruso to produce them. We didn't have the right to say, no, we can't produce it to all parties in the litigation if you ask for it. And by the way, at that point, they knew that the tape existed. They knew the content of the tape. So why were they asking us for it except to play a game of gotcha and then claim that that was somehow a violation of the statute? I think that you should know that when we produced it, we did produce it saying it was for attorneys' eyes only and that it was highly confidential. At no point before or in connection with their request for production did Caruso try to make some motion that it should be produced in some kind of, protected way that nobody else should see it. So really, what choice did we have but to produce it to the other attorneys in the case? That's our obligation under the CPLR. If you look at one of the other claims of use, which is in February 1st, 2004, we used the transcript, or the claim is that we used the transcript by making a motion to dismiss the Illinois statute. I don't understand why we wouldn't have to use that. But again, we weren't cavalier about it. What we did is we attached it in a redacted form. We actually took out all of Mr. Caruso's statements from that. And so it's hard to understand why that would constitute a violation, a use violation, under under any of the statutes. We were responding to the Illinois cause of action counterclaim that had been interposed against us. We filed it when we tried to quash the subpoena of Mr. Jupin in the Jersey court. Mr. Jupin was, the subpoena by Caruso was to get information from Mr. Jupin about what he knew about the conversation that had been recorded. When we made the motion to quash in front of the Jersey court, we redacted this time not only Mr. Caruso's statements from the transcript, we didn't provide the tape, but we also we redacted Mr. Green's statements so that there could be no claim that somehow, if you read Mr. Green's statements on the telephone call, you could ordain what Mr. Caruso was saying. We actually don't think that's true, but in any event, because Mr. Caruso complained about it, we tried to be more careful about it. One thing also in the Jersey court, they don't take like a sealed copy of the complaint, of the complete document. They just get it redacted. I don't think there's an additional defense. Not only were we using it defensively, but there were 4 hours of conversation in that transcript, much of which was not with Mr. Caruso. And he doesn't have standing. There is case law, it's in our brief. He doesn't have standing to object to any recording where he is not a participant in it or conversation. So he couldn't object to the rest of it. They're objecting to our use of it during the course of the depositions. One of the other things to understand about the Illinois statute, which is when the depositions took place, it has kind of a unique fear of crime defense, and a lot of the questions in the deposition really went to that fear of crime. Because the context of this was that Mr. Green had just confessed, like the day before, to a pretty substantial embezzlement scheme involving Mr. Caruso. And Mr. Green had come in with his wife and his mother and his attorney on the phone to talk to Sire's attorney and investigator because he was confessing, because he was claiming that he was being extorted. He was being shaken down by Mr. Caruso and Mr. Grant for more money. We had certainly a reasonable ability to believe at that time that there may have been an ongoing crime. And it was fair game for us to at least ask minimal questions to see if we could establish under the Illinois statute a fear of the crime defense. Finally, I think, you know, certainly at the depositions, counsel were present. We believe that actually Mr. Caruso consented to the counsel present hearing the tape and getting the transcript, but by that time, quite frankly, consent didn't matter. While the statute of limitations may run for that, in fact, the defense to that is that they already knew about it. They already knew about it. How did they know about it? Because Mr. Caruso asked that we produce it in the action in discovery. So everybody had gotten it beforehand and before the depositions. So any disclosure to them that may have occurred during the depositions, it was on information they already knew. And there's just no claim under the statute when somebody already knows it. I suppose really like the one of the ones, and I know I'm over my time, I can go through the defenses individually if you want me to continue. But
I think we're okay.
okay, I can talk about the complaint too, because that kind of stands by itself. And I just want to point out on the complaint and the amended complaint that you have to understand that in this meeting, we had an investigator, we had an attorney, we had Mr. Green, we had Mr. Green's wife, we had Mr. Green's father, and they all were fact witnesses. They actually heard it. So to the extent—
This would have been for the Green action, you're saying, or just in
No,
general?
not in the
Just
Green action.
okay,
I'm just
okay.
talking about the conversation. So when we
In other words, what you're saying is you don't really need the recording
don't
with
need
all
it
this
to make a
independent,
case at all. Don't need—
independent memory.
Right, exactly, and it's admissible, and we don't need the tape. So I think, quite frankly, that the court was correct in dismissing these causes of action. I would like to say that I am troubled by the position of Mr. Fishman and his client that every time we use it in connection with this action, or it's brought up in connection with this action, that they have a new cause of action. And the motion that was brought with respect to this case, because they didn't file what was before Judge Crane on the original motion, and decided themselves to eliminate it, and we brought it to their attention, and they said, no, you do it. And we said, okay, we'll take it on, but you have to consent to it. They said no. And I think you get the idea. It's like a big game of gotcha. It's just, it's not right. And so for Judge Crane to say, this just isn't fair, I think she was well within her rights to say it. And we do have defenses, and we should be allowed to pursue them in connection with the claim about the legality of the tape and the transcript of it. I thank you. I thank you for your patience.
I'll try to be brief because I know it's been a very long afternoon for all of you.
Could you just, for me, answer a question?
Sure.
If the parties were to stipulate to the elimination of this tape for all purposes, forever and a day, could you do that?
So the answer is we could do that.
And if that's the case, that would moot all your concerns about the claimed illegality of the recording and its continuing violation.
With all due respect, Your Honor, it would not. And it would totally solve my fear and my client's fear that this tape will resurface. The idea that Curtis Jackson has a tape of my client is a terrible thing for my client. And if we were to have all of them destroyed and returned, that might be fine. I don't know where they are, but the continued use is one thing. But let me say this, Section 2515 of Title 18 of the United States Code already requires either this court or Justice Crane to do that. So we don't have to stipulate to it. 2515 says it may not be received, if it is an illegal tape, which does not turn on the statute of limitations, it may not be received in evidence in any hearing in state or federal court, so we don't have to stipulate to that. But what it would not do is mitigate the harm to my client from their having used it in public and purported to quote it in the amended complaint in this case. With all due respect to my adversary, that is not a defensive use. When they used it in the arbitration, that was not a defensive use. When they cross-examined him, had his deposition with the recording and the transcript, that was not a defensive use because it wasn't limited just to the, did you consent or not? Do you have a claim under Illinois law or not? That damage to my client, he's entitled to pursue. And so whether, and I also agree that if they want to pursue those defenses in front of Justice Crane in the Supreme Court below, they are totally free to do that. I don't think that those defenses are meritorious, but they are not the basis for a motion to dismiss. Let me just respond quickly to a couple things, and there's a couple other things. One is you asked about intent, Justice, and I don't know whether you meant what Curtis Jackson's intent was when he planted the room bug. It doesn't matter whom he thought he was going to record. Obviously, every time somebody does an illegal wiretap, they never know everybody who's going to get on the phone. They never know who's going to walk into the room if it's a room bug. The intent is to do something without consent. That's the intent here that really matters. My adversary referred to waiver. I have no idea what waiver claim we're talking about, and I'm not suggesting that every single one of the uses was as powerful as the other that they made of that tape. But the fact that they used it at all, knowing for 4 years, now 5 years, that tape was illegal, and there's really, except for the implied consent argument, there is no possible contention that that recording was legal under New Jersey or federal law, and they've known it for 5 years.
So if you use it for some issue or another, are they able to use it to counter what you said?
So the answer is it will depend on the limited use to which you could make it. It obviously can't be the case, can't be the law, that if you are the subject of an illegal wiretap and you sue under the private right of action that Congress and the New Jersey legislature have conferred on people who are aggrieved by that violation, it can't be that in some way you can't point out things about the tape that go to intent and damage because the statute entitles you to punitive damages. But the question before this court today and the question that was before Justice Crane in August is not that question. Respectfully, we may get to that point, but the question before you and before Justice Crane was whether their use of the tape on their own affirmatively is a colorable violation of federal and New Jersey state law. If it is, and if at least as to the subsequent uses in the complaint and the deposition, if those claims are timely, this case should proceed on that ground. And in that light, they are not entitled to use the recording in evidence. If we can't use it too, that's fine, except to the limited extent that if it limits us to our statutory right to pursue damages or punitive damages, we'll have to work out with Justice Crane how to do that. But it can't be that all of those reasons mean that we can't sue at all for what is a blatant violation of state and federal law. Thank you, Justice.
Thank you.
Thank you.
Thank you both.
So, sort of, yeah. Molly, nice to see you. How many times have you been back on your feet since you left?